Yes.
I'm filing my affidavit date.
Why 1 week?
Affidavit is ready, madam. I'm just required to file.
No. It goes for 4 weeks. At the request of Mr. B. Sharma, the Learned Standing Counsel for the Railways, matter is adjourned for 2 weeks.
For listing of a matter where we are required to file an amendment of the cost. There is a notification. It says it can be done by the branch of the vehicle. Now the branch is saying that you mentioned the matter to the court's punishment. Because the court is high up.
But Mr. Das, the thing is, understood, but don't you think that it should be mentioned before court number 5?
Because your lordship has passed an order on this thing.
Understood, but matter pertains to which year?
This is
Then there is jurisdiction like that.
court file.
What's the consent of this? It is adjourned for the day and this previously maybe had lost his father, so he would be able to appear today.
Who?
Meanwhile, 3 weeks of time shall be granted for a filing of the affidavit in opposition.
Interview is here.
Interim is there. At the request of the Learned Counsel appearing on behalf of the respondents, matter stands adjourned to be listed again on 8th of November. The interim order passed earlier shall continue till then.
I can probably not forget this possible. But all the way from
Cause of action does not remain. Influxus. Mr. M.H. Ahmed, the Learned Counsel appearing on behalf of the petitioner, submits that the writ petition has become influxus. Taking into account the above, the writ petition stands closed. Interim order, if any, stands vacated. You are appearing for? Oh, that matter. Why haven't you filed your affidavit till now? You are a petitioner. At the request of the Learned Counsel for the petitioner, matter adjourns for 4 weeks. 4 weeks. I don't give any adjourn for 2 weeks. Yes, what is it? Interim order.
No.
At the request of the Learned Counsel for the petitioner, matter stands adjourned for 4 weeks.
Regarding item number 17, madam. This matter pertains to non-payment of contractor fees, madam. This is for 80 matter, madam. Can you take the current state of instruction, madam?
We'll see. At the request of the Learned Counsel for the petitioner, matter stands adjourned for 4 weeks.
My lordship, I'd like to mention, serial number 2. My lordship, with due respect, I beg to state before this humble court, that is running late due to the excessive claims that happened last night, and due to the overwhelming traffic conditions, we would not be able to take it on time. Therefore, I urge this humble court to take the matter after half an hour. Can we
2 o'clock. 2 o'clock. This is only for implement of parties, Mr. You do it.
My lordship,
If I can't pass an order in your favor, I will adjourn. Okay?
my lordship, actually, last night only I got to know about the case.
Not necessary. We'll see. No adjournment. We'll see.
item number 18 on behalf of Mr. S. Samariano.
Yes,
Okay, one of the people are that. So, which I give them for this, actually the right letter.
interim order.
So,
At the request of the learned counsel for the petition, a matter adjourned for 4 weeks. Hmm. Huh?
The chariot. The hundred of bread.
At the request of the learned counsel for the petition, a matter stands adjourned for 4 weeks. So nothing remains. Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner, submits that the land records have been duly corrected on 13/11/2019, and as such, nothing further remains to be decided in the instant writ petition. Accordingly, the instant writ petition stands closed as it has become infructuous.
First delegating item number 1.
Yes, which order?
the order has been passed.
Mr. Goswami, you are the petitioner or the respondent?
I'm for the response. I'm for the response.
Fantastic. Kindly change your places.
Prior to that, I will come and if the is accepted.
Hmm?
I is coming to. the-
So what? Change your places. Because it becomes very difficult for this. You are asking for vacating of which order, Mr.? Hey, this IS, so many IS are coming. Where is the main writ petition? Main writ petition order is where? Operation of the letter dated 3/12/2019 passed by the respondent number 5 shall be suspended. Let us see where is that order.
Order looks to be fine. Annexure 7 of the.
3/12/2019, Annexure 8. Page 27,
Annex, page 25.
page 29,
Not the repetition,
page 29.
page 29.
Yes. And who are you?
We are resident of the locality, also we are facing problem because of the distance created in marriage problem. We cannot sleep together. Sleep for long time because the records and everything were last week, marriage on in night, and that was the that license. We have filed complaint to the municipal board that some steps to be taken for our objection. There are some so-called notice has been issued to him to stop the nuisance. He has failed to control the nuisance. Thereafter, looking this order has been passed. He has filed a petition stating that no so-called notice has been issued, no legislation highlighted. That is why this order has been stayed.
Is it?
Kindly see the so-called notice of matter.
Have you mentioned that no show cause notice has been issued?
Yes, I mentioned that, but this taking the fact matter. The fact is that he lodged a complaint for the executive officer non-binding municipal board. That was in 2017. And it was disposed of on 17/12/2018 by sending a letter of complaint. And I have complied with that with my mother, that it is not in a position matter. Thereafter, he lodged a different complaint before the ADM non-binding matter and non-binding. That complaint was lodged on 6th of April 2019. Thereafter, once the proceeding was drawn up on 11th of April 2019, and accordingly it was up to me, and I submitted my reply in the month of March 2019 matter. Thereafter, that proceeding was pending. Still, that proceeding is pending. But when this impugn order was finally issued, Before that, on 6th of November 2019, my lord, they issued a letter. That is the case, my lord. It's 23, my lord. 24, 23, 24, my lord. Yeah, it's correct. Page 23, my lord. Annexure 6.
Hmm.
It is hereby informed you that the meeting hall, namely Mandalam Vibhaga 1, is being run by you in ward number 7 at Palla Road number. The state Vibhaga 1 is not given any kind of license from this office. Hence, we were told to submit reply in writing at the office of the undersigned within 48 hours of receipt of this notice. As to why the Vibhaga 1 shall not be seen from running illegally without any departmental license. So, madam, this is purely regarding departmental license. As in response of this paragraph, we submitted our reply. That is in the next page, madam, page 35, madam. Annexure 7, madam. Yeah, madam, it is, may I read, madam? It is respectfully informed with reference to the above mentioned subject and reference that at the time of starting our various work on Mandalam Vibhaga 1, is ward number 2020, along with all necessary documents were submitted at your office for trade license. Accordingly, on completion of departmental inquiry, last month, 1/2016, the licensing authority on receiving the municipal tax for trade license permitted to open the marriage hall and informed that the trade license will be issued in time. It is informed for your information that subsequently on 36/2017 for 2017-18, on 26/2018 for 2018-19, and on 4th of 2019 for 2019-20, municipal taxes for trade license have been paid. So it is false that the same marriage hall is being run illegally without any permission from the department because for obtaining the trade license, all the documents have already been submitted and taxes have been paid. Further, both of us have taken loan from the bank for ourselves.
Just 1 minute, huh? Hey. Hey, you should do a single one. No,
The next one, madam.
one.
It is stated that continuous business with 1/2016 for last 4 years till now, the permission granted on receipt of municipal tax without providing the license of various work is being run. It is only due to the on the part of the department on receipt of taxes also, the license has not been given. In fact, despite the repeated visit to the office also, the license could not be obtained. There is no negligence in our part. Next page, madam, page 26. Further, in the present situation, if the marriage hall becomes still, it will cause financial loss and mental disturbance to us, ending up our way of self-employment. Therefore, as per your direction, I mean, file the reply in writing before the estimation time, which is here to provide us the trade license for keeping of our way of operation open. So, madam, this was the madam reply we filed because of 7th of November 2019, madam.
Who is appealing for the Nalbari Municipal Board? You are appealing. Just tell me, on one hand, why are you taking the trade license fees? Why? No, why are you taking and you are not giving the license to operate? But why? Why you are taking the trade license? Trade license means what? It's a professional fee, tax, which is being taken by the government, by the municipal board for running, for carrying out any trade. That's a trade license. On one hand, you are doing it. And on the other hand, why you are not issuing the license? And then, on one hand, that is it. You issue a show cause notice to him on the ground of trade license. He replies on the license and you pass an order on the basis of a public complaint. How is it? How are you doing it? So the show cause notice which has been issued has no reasonable nexus with the order passed.
licenses, how do you obtain them?
Absolutely. You do it on the basis of license not being obtained, take a decision on that. But why you have, on one hand, you issue a license for, issue a notice for not having a license. He replies of not having why he doesn't have, and you pass an order on the basis of public complaints. What is this? We set aside this order. Then you take a call, whatever you have to do. You take whatever you do. Bring the so-called proceedings to a logical conclusion, you bring it. But this order has to be set aside. That's notice.
My submission is here is a PI regarding the nuisance created to the area again. So the PI is the direction for the school. By the order to that for maintaining and arrange for the locating here should be some guidelines. Guidelines have been determined that the determinants of the school that it should not be created in nuisance with the public has to be part of this in the marriage hall and everything.
But Mr. Goswami, tell me.
So,
Notice has been issued in respect of a cause. He replies in respect to a cause. And you pass an order under B cause. Can it be permissible? Then obviously it is a case where no natural justice has been violated, had been followed.
and before that,
You are to, the municipal board has to say that look here, these are the public complaints we have received. What do you have to say? Apart from the other thing, let him bring him to as to whether license is required or not. That is another aspect. Apart from that, the municipal board to have brought it to his attention that these are the public complaints. What are you going to do? And you bring the high court's orders in Guwahati there and show it. And then the municipality take a decision on that. But how can you do it when the cause is A and you are doing this?
that is the order of closing is. on different-
Because you see, keeping this matter pending, the vacating does not arise. Keeping this matter pending is not in your interest also. So we set aside this and giving the liberty to take, after giving him a proper notice on public complaints.
Really, the public complaint, public complaint, is regarding nuisance.
That he has already complied.
No, he has said this compliant, but we have stated because of the marriage or there is a congestion. and-
You are saying it different. For that, when he says that he has complied and the municipal board has duly accepted, the municipal board has not done anything on that thereafter. That chapter is closed there. You have submitted any representation thereafter, very well. The municipal board has to issue him a notice for that, that these are the complaints. What do you have to say?
That he has given reply to the record to the after. He has given reply that we have stopped creating noise in the locality and everything. He has submitted a representation. Thereafter, the authority has not passed an order. This order has been passed, though it is already about complaint. We have not been implemented in this case. They have obtained stay order. Thereafter, we have come to the order interim order that's been passed by this on our court. And we have to know that it or not because of the license is directly closed, not because of the nuisance created. As per provision of Municipal Act 219, when nuisance is created, there should be so far and there should be closing and everything. That provision has not been applied by the municipal corporation. They have only said that no license you are operating in the area, so it was closed. On this ground, it's not sustainable. The order is not sustainable.
No, here they don't say that in that. You don't have a license.
But only thing is, when we have made a complaint, we have been issued report.
But where that's supposed? And he says that he has duly complied with that. And the municipal board is satisfied with it. Then, unless they say, "Yeah, look here, we are not satisfied with your compliance, and as such we are
I
calling."
understand. I understand. Only thing is, also,
Now, should we further delay?
procedure is wrong.
But Mr. Goswami, should we further delay the proceedings, delay these proceedings any further?
Municipal authority may be directed to take action as per law if it is possible.
That
Now,
is the
we have
best.
made a complaint.
It's okay. Let us,
Thereafter, look at so-called notice will be issued on 7/11.
Where?
Okay, we have filed an affidavit when we have stated. Page 31 of the application.
Page
Uh,
30.
What complaint? About complaint is at page 23 of it. And we
Page?
put that Page 17 onward. Page 17 is the complaint, is the complaint.
Is it dated?
The date was-
No date.
It was the 4/10/2017.
2017.
Then
Then Lordship, we have made complaint to the deputy commissioner also. That was registered as 19 and of 2019.
that is pending.
That is pending. And hereafter, Lordship, he has been issued. Next complaint is Lordship will find at page 26. That is 6/12/19.
Huh?
6/12/19,
Page 26.
page 26. Hereafter, ADM has issued notice, Lordship,
This is being given to again the ADM.
that is pending.
We are not concerned with the ADM. We are concerned with what you have done to these people.
Only.
Now here there is this which has been given on this date, 17/12/2018. Sound pollution.
That would be, that procedure adopted by the municipal authority is not correct. That's what our complaint.
Minus my understanding is that under section 299 separate procedure is there. But section 220 of the municipal after municipal is doesn't say like. It is that if there is any complaint matter, then can be verified that even the nuisance can also be removed.
All these things are not necessary. Let me. The instant writ petition has been filed by the petitioner, by the petitioners, being aggrieved with the order dated 3/12/2019, whereby the executive officer, Nalbari Municipal Board, had directed the petitioners to close down the marriage hall until further orders. Pusto. It reveals from the records that the petitioners claimed that they had applied for a license to operate the marriage hall in the name of Monoram Vivah Bhavan in the first floor of the building of the petitioners. Admittedly, no license have been issued by the Nalbari Municipal Board, but the Nalbari Municipal Board have issued a trade license to the petitioners. No, trade license not issued. Applied. The Nalbari Municipal Board however have kept the application seeking license pending. It is an admitted fact that till date, no trade license has also been issued to the petitioners. But the Nalbari Municipal Board have been realizing trade license tax from the petitioners from time to time. This aspect of the matter is evidence from Annexure 2, 2A, 3, 3A, 4, 4A, 5, and 5A to the writ petition. It is the further case of the petitioners that on 6/11/2019, a show cause notice was issued to the petitioner by whom? Huh?
Executive Officer, Nalbari Municipal.
By the executive officer, Nalbari Municipal Board. Informing the petitioners that the said Vivah Bhavan / marriage hall was being run by the petitioners without a license issued from the said office. Under such circumstances, the petitioner was asked to show cause within 48 hours of receipt of the said notice as to why the marriage hall should not be sealed for running illegally without any departmental license. The petitioners, upon receipt of the said show cause notice, replied to the executive officer, Nalbari Municipal Board, by the communication dated 7/11/2019, intimating that the petitioners have duly applied for the license for operating the marriage hall. But the said license has not yet been issued, although the Nalbari Municipal Board have been realizing the municipal taxes for trade license on 30/6/2017 for 2017-18, on 26/6/2018 for 2018-19, and on 4/4/2019 for 2019-20. It is not known that what steps was taken to the said show cause notice dated 6/11/2019 and the reply submitted by the petitioner on 7/11/2019. But on 3/12/2019, the executive officer, Nalbari Municipal Board, by the impugned order, directed the petitioners to close down the marriage hall on the ground of public complaints. It is under such circumstances that the petitioner had approached this court by filing the instant writ petition. The record reveals that this court, by an order dated 8/9/12/2019, issued notice and in the interim state the impugned communication dated 3/12/2019. The same interim order thereupon have been extended from time to time. This court further finds it relevant to take note of that the respondent numbers 8 to 7 to 13, 7 to 12, 7 to 12, huh?
They have been included after filing application. for-
And that is what. Relevant to know that the respondent number 7 to 12 filed an application before this court seeking implement to the instant proceedings on the ground that at their behest that the impugned order dated 3/12/2019 was passed. This court, by an order dated 8/10/2020, in IA Civil number 95/2020, implemented the respondent numbers 7 to 12 to the instant writ proceedings. This court further finds it further relevant to note that an application was filed by the respondent number 7 to 12 as applicants, which was registered and numbered as IAC number 2249/2020, seeking vacation of the interim order by which the impugned order dated 3/12/2019 was stayed. The record further shows that the newly implemented respondent number 7 to 12 have filed an affidavit in opposition, stating their stand in the instant writ proceedings and defending the impugned order dated 3/12/2019. The respondent number 5 had also filed an affidavit in opposition, stating inter alia that the instant writ petition so filed by the petitioner was baseless and due process was followed while passing the impugned order dated 3/12/2019. This court have also heard the learned counsels for the parties. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that initially, on the basis of certain public complaints, a notice was issued to the petitioner on where
17/12/2018.
7
17/12/2018.
on 17/12/2018, and the petitioner was asked to comply by the executive officer of the Nalbari Municipal Board. Pursuant thereto, the matter stood closed upon the petitioner complying. The learned counsel further submits that on 6/11/2019, a notice was issued to the petitioner only on the question of the petitioner not running the marriage hall with a departmental license, to which the petitioner duly replied on 7/11/2019. The learned counsel further drawing the attention of this court to the order dated, impugned order dated 3/12/2019, submits that the reasons for which the so-called notice was issued is completely different in the order, in the reasons for which the impugned order was passed. And as such, the action of the Executive Officer, Nalbari Municipal Board, in passing the impugned order violates the principles of natural justice. Ms. Yudas, the learned counsel appearing on behalf of the Nalbari Municipal Board, fairly admits to the fact that the notice was issued, that the so-called notice, the reason for issuance of the so-called notice and the passing of the order, passing of the impugned order and the reasons for passing the impugned order are different. She, however, submits that liberty may be given to the Nalbari Municipal Board to bring the said so-called proceedings to a logical conclusions on the basis of the provisions of the Assam Municipal Act 1956 and the rules framed therein under. Mr. S.K. Goswami, the learned counsel appearing on behalf of the private respondents number 7 to 12, submits that on account of the marriage hall of the petitioner, it has become difficult on the part of the respondent number 7 to 12, as well as the other people in the locality, to reside, as in view of the nuisance so created by the marriage, on account of the functions held in the marriage hall. He further submits that there has been various complaints filed by the respondent number 7 to 12. In fact, on 7/11/2019 itself, a complaint was filed. However, the Nalbari Municipal Board had not taken any action on the basis of such nuisance be created. He further submits that in a PIL being registered before the division bench of this court, being PIL number 2073/2013, the aspect of the nuisance being created by the marriage halls in the residential areas had been duly taken note of, and there has been certain directions passed by the division bench of this court. Under such circumstances, the learned counsel therefore submits that the respondent authorities, the executive officer, Nalbari Municipal Board, was within his authority to pass the said order. Upon hearing the learned counsels for the parties and perusing the materials on record, it seems seen that the reason for which the so-called notice was issued for the reason it was issued on 6/11/2019 on the ground for the reason that the petitioner is running without a departmental license. On the other hand, the petitioner had duly submitted his reply on 7/11/2019, stating inter alia that the petitioner had applied for the license in question. The respondent Nalbari Municipal Board had kept the application seeking license pending, but on the other hand have been realizing the trade license fees from 2017-18 till date. It is also seen that although the show cause notice was issued for not having a license, but the reason for passing the impugned order is on the basis of certain public complaints. The same public complaints, however, admittedly have not been served upon the petitioner. Under such circumstances, in the opinion of this court, that the impugned order dated 3/12/2019 suffers from and is in violation of the principles of natural justice, and accordingly violates the mandate of Article 14 of the Constitution. Accordingly, consequently, the impugned order dated 3/12/2019 therefore stands set aside and quashed. Before concluding, this court further finds it relevant to take note of that in view of the setting aside and quashing of the impugned order, the so-called proceedings so initiated on 6/11/2019 stands revived, and the Nalbari Municipal Board is given the liberty to bring the said so-called proceedings to a logical conclusion. Further to that, this court apart from the said, this court can also be not unmindful of the grievances of the private respondent numbers 7 to 12, who on account of the alleged nuisance being created by the marriage hall of the nuisance being created in view of the functions being held in the marriage hall of the petitioners, have lodged various complaints. The Nalbari Municipal Board is directed to take appropriate action on the basis of such public complaints being submitted by the respondent number 7 to 12. But in doing so, the petitioner be given due notice. With the above, the instant petition therefore stands disposed. The other I cannot in view of what has been already observed in view of the order of judgment and order passed in the accompanying writ petition, nothing survives. That I got. তাতে এটা ওপৰত এটা লাইন এটা লিখি দিব এইটো set aside and quash পিছত দেই It is also seen from the writ petition that the petitioner has sought for a relief for directing the respondent Nalbari Municipal Board to issue a license to the petitioner for carrying his marriage hall. Taking into account that the said application has been pending, as stated, as alleged by the petitioner, it is the opinion of this court that the Nalbari Municipal Board has to take a decision on the said application. Under such circumstances, this court therefore directs the Nalbari Municipal Board to take a decision on the said application within a period of 4 weeks from the date a certified copy of the order is served upon the executive officer of the Nalbari Municipal.
Considering the order of the hearing. In fact, residential area no legislation. Considering the order of the hearing. As well as considering the hearing.
Mr. S.K. Goswami, the learned counsel appearing on behalf of the respondent number 7 to 12 submits that the said respondents would submit the certified copy of the instant order to the respondent number to the executive officer. And within 4 weeks from the date of a certified copy is served upon the person. It is, however, observed that the Nalbari Municipal Board, while taking a decision in respect to the license to be issued to the petitioner, shall take into consideration the extent provisions of law.
Okay. Nothing like that, madam, 4 weeks. They will not be done.
I have set aside that. Is there any order not to do it? If they pass, you do something. Why should I?
And number 2, order number 40.
Yes, Mr. Counsel, why you are not allowing your junior counsel to do this matter? Then only you will learn. It's a simple matter of impleadment. I told him that if it is a case of impleadment, if it goes against you, I will hear only when your senior comes. Let him do it. Let's see what he has to say.
I'm not totally aware of the facts of the case.
Not necessary. What is this? It's only an application for impleadment. You want to implead whom?
Village, Santara, the post office, Mirza, district Kambu. Some page number 5.
Okay. Now I think, come back. Let him come. Yes, what is the reason you want this impleadment?
Because they are the recorded riot.
Huh?
They are the recorded riot that others in India in the matter they are not new party. That the leader number 1, Mr. Guru, one of
No, but your application is completely silent. Why do you want it? It is just a vague application. Is this type of application you do it? Is the way? There's nothing mentioned anything.
Paragraph 1, madam.
Paragraph 1, what you are saying that they are the riots.
Under the Gabadar Chaudhary. Gabadar Chaudhary is the original Pakta Hoja.
Then
And under him, my lord, this person.
how is it relevant?
Tenant.
No, how is it relevant?
They are the recorded tenant.
So
And they are also entered the CR, and they are not their party in this case. They are like.
why haven't you not made them parties at the initial time? What is the case about?
My lord, they are the awarded of as per my lord.
Huh?
LA case number 11 of 2012. This order passed by the commissioner.
Let us see that order passed. 17/10/2017. Where is that order? Yes, tell me why you are aggrieved?
Yeah, my lord,
The compensation has been allotted in the name of Sudha Jain as Patradar of Bhimman and also in the name of 7 traders. Whether the rights are still recorded rights, and therefore the prayer of Sudha for non-payment of any other has been rejected. So your case is that this amount should be only paid to you and not to the riots.
no,
Who is Sudha Jain? Again, the problem arises. You know who has to appear where? You are You are the riots.
Right.
Okay.
And some riot already.
And okay, madam, tell me, your case is that Sudha, you should only get, not them. Fantastic, very well. So there is a decision by them. And as such, the payment must have been made. You are claiming, has the payment been made?
41 lakhs.
You approached the respondent, this is done under what provision? Under what provision this application, the acquisition is done? Tendency. What is this acquisition under the what provision? You don't know, huh? So, engaged matter you have not, you don't know. Who is appearing for the government? These matters, who is appearing? Madam, don't appear unless you know anything. Yes, Mr. Bhattacharjee. This acquisition is done under what provision? This is done in 2012. Most probably, this has been acquisition for what? IIT. So IIT must have been done under the LA case. This is done in 2012. Must have been done under the old Act, Land Acquisition Act. So Land Acquisition Act, if it is there, when is this order passed? Order passed when? 2020. So if it is done under the 2020 Act, madam, there are two ways. This court will today dismiss your application petition. Or you want to go there. I will direct the DC to deposit the entire amount before the collector, before the court. And there are two ways. I'm telling you, either dismissal. Because you see, all the rights are person interested within the meaning of the Land Acquisition Act. They will have to get it. If it is a question of relinquishment is there or not, this aspect of the matter can who has relinquished and in whose favor?
There were 7 rights from this matter.
In whose favor? How can they favor you? Relinquish in your favor the rights? Tell me. That is an ABCD of this the 1971 Act. The rights can relinquish in favor of you. The rights can relinquish to the state government. That's the law. Isn't it, Mr. Bhoya? Can the rights relinquish in favor of the any owner?
Yeah.
That is another thing. Let us go, let us admit that there is a relinquishment. But can there be a relinquishment in favor of the landlord? What I know, the relinquishment has to be only in favor of the government. And then the government may give right khatiyan to somebody else. Because who has given him the right? The right has been given by the government. How can he relinquish to somebody else? What? Where is your senior? This is not a case where impediment or non-impediment and all. And why haven't you not made these people a party? No, let us see how many impediment persons are there who are the riots.
Their fathers were
As
minister.
per the reports, land records, the recorded rights are 1, Suren Boro, Dom Boro, Jugula Boro, Sugar Boro, and 7. These are the 7. Have you made these 7
No.
parties?
They are not made party and they are.
Yes, how? Your with petition should be dismissed on that ground. Yes, we have made these people party.
They are not added by law. Suren Guru and therefore his son Rudra Guru.
Oh,
he has got-
No, they have been made party. And who are you?
I am the son of this,
Which right?
this 7 number of Riot Show, page number 6. And there, legal hair appeared, it was also 500.
No. Who are you?
I am my lord.
These rights are all there from 8 to 17.
They are the legal hair of this riot. This riot already expired, my lord.
Are you saying Sukuru Boro has expired?
Yes. My lord, Number 1, Suren Guru, the Rudra Guru is the son of Suren Guru. I am here.
Suren Boro, where is Suren Boro?
Suren Guru, my lord, page 66. Riot number 1, Suren.
Suren Boro, Deepak Boro is already there.
Suren Guru,
Deepak Boro is already there. As response number 9, 8.
but I am not on that, but because of my lord, this 7 number of riot, so far page 66 is here.
Ah. Yes.
Suren Guru, year number 1,
Suren Boro's son is already there.
Suren Guru's son Rudra Guru is here by carrying.
Suren Boro's son Deepak Boro is already there, number 8.
And Rudra Guru is here. And here my lord, Holy Das, also one, year number 6.
Horimol.
Yes, his son, here my lord, imprisonment petition, year number 2, Arvesh Sharma. And Viren Chandra is the son of late Raghu. And
When this document has been given by this Swema at page 67, yes, DC, who is appearing? Yes, when 67, page number 67 of the writ petition has been given to you, why are you deciding all these things? Whether they are to get it or not? Tell me, under what provision? This is an objection being given by them. Why are you deciding all these things? This is a case of apportionment. Who is to decide? Who will decide? Another one, page 69. Where is your senior? Get your senior. We set aside this order and direct them to immediately do it. We'll take it up at 2. This type of matters should not remain, because what is happening, the government does not know. If there is a delay, there will be an interest. Then ask your senior to be there at 2 o'clock.
About the permission.
Yes.
Here the plot of land, is a bigger by law. That number 194, that number 30. And now my lord, now is the village, cutting very well. And there are
To declare the petitioner fit and eligible to hold this patta land which was settled in favor as per the settlement order dated so and so. Directing the petition authorities to stop eviction so and so.
Here my lord.
You have been given settlement.
Yes, sir.
Where is it?
Next one.
I, Jila settlement officer by this, what is this?
Page 12.
Oh, Khiraz made, this one. So this has been given for which land? Patta for Miyadi Khiraz Patta 30 of Dag number 194. Okay, you have been given this.
Yes.
Then,
I will receive.
hmm, Then you are Sahir Ali.
Yes.
Sahir Ali.
Here of my 4 page 20 minutes.
Huh.
I think the permission is given by the top of the top of the.
Then why are you before this court?
He's running a cell.
Huh?
Hotel my lord, private hotel.
Huh.
He's part of that.
Huh.
The government my lord. Thoroughly says that, thoroughly that block my lord, there are some government land.
Huh?
There are some government land thoroughly with that area my lord. Government attempted to evict that. In the light of that, my lord, he was also directed to take it his my lord.
Where is that? By Barbeli.
Barbeli.
Barbeli one can't do.
Then, well, he came to the honorable court. In this regard, my lord, the deputy commissioner, my lord, who has filed the reference to find a deputy commissioner.
What did he say?
He said that regarding land, regarding the hotel, he has nothing to say, but only he for a question, my lord, the hotel is running, it is not only personal land. It is on another government land covered by the government, 7. But without annexing any document regarding survey, report, my lord, anything, all he has stated. But here, my lord, I have annexed 4.
Then also, they have to issue a notice.
Yes.
Or an information asking you to vacate. Where is that? Look, the instant petition has been filed by the petitioner. Seeking for a declaration that seeking a writ of mandamus to stop the eviction of the petitioner from the land covered by tag number 194 included in periodic patta number 30 and to allow the petitioner to continue his rightful and legal possession of the land. From a perusal of the materials on record, it reveals that on 23/2012, a periodic lease and any the annual lease.
Here we can.
How is it Miyadi? Miyadi, no, it is an annual lease.
My lord, case will, my lord.
Yeah.
Stop, my lord. Here we can.
Huh? No, where is it? Period is what? A periodic Shiras Patta was issued to the petitioner. Of an area of land measuring how much? 3 bighas covered by DAG number 194 and included in KP Patta number 30 of village Kothani Bari under Moza Nahor Bari in the district of Punitpur, Assam. The record further reveals that the petitioner have been paying the land revenue in respect to the said land And his name was also duly entered in the record of rights. The petitioner claims that the Thelamora Gram Panchayat had, by the communication dated, by the order dated, by the no objection certificate dated. What is the date?
31/8.
Where is it?
Case 20, my lord.
Where is the date?
31/8.
Where do we get the date? Oh, 31/8/2009. Granted the petitioner permission to run a line hotel and a cycle shop. You claim that these are there in your land?
Yes.
The petitioner claims that his line hotel and his cycle shop is situated over the land which was settled upon the petitioner. And the petitioner is running the said line hotel and cycle shop from his place, from his lands. It is the further case of the petitioner that the deputy commissioner, the office of the deputy commissioner, where? Deputy commissioner, which place? Sonitpur. Had taken steps for eviction of government lands. And the petitioner was also informed that he would be evicted from his land. And it is under such circumstances that the petitioner has approached this court by filing the instant writ petition under Article 226 of the Constitution. This court, by an order dated 9/6/2017, issued notice and further directed that status quo as regards the petitioner's land be maintained until further orders. The said order has been continuing since then. The record further shows that the respondent number 2 filed an affidavit in opposition through the Assistant Commissioner Punitpur Tejpur Assam. In the said affidavit in opposition, it is mentioned that the petitioner is running a line hotel in village Rohinibin under Moza Nahorbari, covered by Dag number 7, in a plot of land measuring 2 bighas 2 kathas 6 lecha, which is a government land. It is denied that the petitioner is having his line hotel over the land which was settled to the petitioner. It was also stated that the petitioner have encroached it was also mentioned, stated that the land which is being encroached by the petitioner is situated near National Highway 15 under Dag number 7 at village Rohinibin, whereas the petitioner was settled under Dag number 194 of KP Patta number 30 at village Kothanibari. Further to that, it has also been mentioned that the petitioner is illegally encroaching the said land of the government by unlawfully running a line hotel and by digging a fishery tank on the government land. I've heard the learned counsels for the parties and perused the materials on record. From the materials on record, it transpires that the petitioner have been issued a patta in respect to a plot of land measuring 3 bighas, covered by DAG number 194, included in KP Patta number 30 of village Kothanibari under Moja Nohorbari in the district of Ponitpur, Assam. The petitioner cannot be evicted from the said land by the respondent authorities other than by following the mandate of law. As the petitioner has a permanent transferable right over the said land. The no objection certificate so issued by the Telamora Gaon Panchayat, thereby permitting the petitioner to have a line hotel and a cycle shop, does not mention in which area the said no objection has been issued.
It has to check it matter, but very clear.
Huh?
It has to reflect it down, covering very clear.
It's okay. The no objection so issued by the Telamora Gaon Panchayat dated 31/8/2009 to the petitioner to carry on the business of a line hotel and a cycle shop has been mentioned as is at village Kothanibari. However, there is no DAG numbers or patta number mentioned, thereby identifying which land. Be that as it may, from the affidavit filed by the respondent number 2, it transpires that the petitioner is, it has been alleged that the petitioner is not running his line hotel. Now he is carrying out the business of a line hotel at village Rohini Bill under Moja Nohonbari, covered by DAG number 7, in respect to a plot of land measuring 2 bighas, 2 kathas, 6 lecha, which is a government land. It has also been specifically mentioned that the land where the petitioner is in occupation, he is carrying on his line hotel, is not covered by the periodic patta land. Therefore, the question arises as to whether the petitioner's line hotel is situated at the periodic patta land of the petitioner or the government land. This court, upon taking into account the conflicting claims of the parties, is of the opinion that prior to evicting the petitioner, the respondent authorities has to ascertain as to whether the petitioners petitioner is carrying on the business of a lime hotel as well as fishery, as alleged in the affidavit filed by the respondent number 2 in his periodic pattala or at Dag number 7, which is a government land. The said aspect shall be done, the ascertainment shall be done, ascertainment, the necessary verification shall be done by the respondent, by the Deputy Commissioner, Punitpur, or through his delegate on the basis of the relevant revenue records. It is made clear that if the petitioner is in occupation of his periodic patta, is carrying on his line hotel in the periodic patta land, the respondent authorities shall not disturb his possession. It is also made clear that if upon verification it is found out, upon field verification as well as the verification of the revenue records, it is found that the petitioner is in occupation of government land, the petitioner may be evicted as per the provisions, as per the established provisions. I've given, do whatever you feel like. Not necessary. What notice? I've given it. It's not- You are going to do where?
I don't. Item number 4.
Yes. Structures. There is no perhaps business. Either it has or has not. Huh? Yes, Mr. Das, what do you have to say?
Who is running the garden, Madam?
Who?
He has not been a party in this.
Somebody is running the garden.
A receiver, funded by us.
Yeah, they have not paid their dues.
No, Madam. There's a present statement of the which is before the present, the liability to Madam 88 last 74,000 and 11. Certificate amount was my lord, recovered certificate amount was 1 crore 25 lakhs 98,000 total 26. Again, here we have deposited.
Deposited when?
Just amount is prior to the state people.
Prior to the request. So balance is 41 lakhs.
41 lakhs and then the interest will come later for the delay in depositing the period amount, madam, then definitely it comes to about 88 lakhs 24,000.
Are you saying that 41 lakhs at the rate of 15% would be only
No, 40, my lord, for the entire amount retired, that is certificate amount.
That's good.
Under the amount of interest issue charge for delay, the amount.
Therefore, you see, it is almost 42 lakhs.
Right.
42 lakhs per, you are saying that this was deposited prior to 2017. If it is so, then 6 years. This can't be. If it is 15% is the interest, the interest will be per year on 40 lakhs would be how much? 15% per year will be 40 lakhs would be almost 6 lakhs per month per year. So then for 6 years it will be much more. So are these payments of 83 lakhs made in the meantime? You get your up-to-date instructions. When? When can you get it? Okay. Mr. N.C. Das, the learned counsel appearing, senior counsel appearing on behalf of the Assam Tea Employees Provident Fund Organization submits that as per his instructions dated 19/9/2023, an amount of rupees 88,74,011.72 is due to the petition, due from the petitioners. And on account of the stay, on account of the interim order passed, the respondent authorities are not in a position to do the needful. This court has specifically pointed the question to him as to whether the petitioners during the pendency of the writ petition have paid any amount. The learned senior counsel submits that he shall obtain his instructions within a week. Your name? M. Pandit. Mr. M. Pandit, the learned counsel appearing on the petitioner, submits that he has no instructions from the petitioner. List the matter again on 27th of September 2023. The instructions were submitted by Mr. N.C. Das. The learned senior counsel is kept on record and marked with the letter X. Yes, madam, what is your instructions? Huh? Hmm? Yes, Mr. Sakya. What do you have to say? What type of these matters are here? These matter has to be either before a civil court or the criminal court. Already FIR has been registered. So investigations are going on. What is there to do? What is this court going to do?
I have heard that the police is not succeeding.
Huh? Maybe if it is not charged sheeted, then you lodge the complaint. You have to file an opportunity to file a Naraji petition. Your prayer, I've seen it to investigate. They have investigated. And if you are not you are aggrieved by the investigation, appear before the authority. Madam, you find it at 2 o'clock. What is the status of this FIR? What is this FIR, or has anything been done? We want whether the charge sheet has been done or FIR, when it has been done, and before which court. You are appearing for. So you just get that information at 2. These matters can't remain unnecessary. Have I asked you? So what? No, Mr. Ghosh, am I asking you, or have I asked you a question? The moment I find that your presence is required, I will do it. Only thing is, if you are not appearing, your name would not be recorded. That's all. I don't need. You do whatever you learn.
I can see.
But 2 o'clock, this matter has to finish. Yes, what remains in this? Infructuous. Mr. R.M. Dekar, the learned counsel appearing on behalf of the petitioner, submits that nothing survives in the instant repetition. Accordingly, the instant repetition stands closed on with as it has become infructuous.
7.
Petitioner has expired. Then,
Okay, allowed to file.
when did the petitioner expire? Huh?
11, 12,
21. And we are having a status quo order.
yes. What has already been.
Until further order, status quo as on today in respect of the boundary shall be maintained, and the petitioner shall not reveal the boundary, portion of the boundary which have been demolished. It has been informed to this court by the learned counsel appearing on behalf of the petitioner that the petitioner had expired on 11/12/2021. Under such circumstances, the learned counsel for the petitioner seeks for an accommodation so that effective steps can be taken in that regard. List a matter of 4 weeks. Status quo is until further orders. Why should I say? Until further orders, not necessary. If it is until further orders, it is not required to be extended. And if I extend it, I will extend it to a next date, and it will be more in your trouble.
8.
Yes, who is appearing? Revenue, home and political, revenue. Any information? This is the extremist attack. You come go. To dispose of polio. And applied this thing and it last line to extremist stockist. Last line at the it is made clear that if any payment has been already made to the petitioner, the question of any verification is not arise. Disposed. Hey, get on number. This is PR Monto for every. This is the extremist attack, 1 lakh and 2 lakhs and all this. Yes, what, Mr. Bora, what are these challenging? What are they challenging?
Sorry.
Yes, what are you challenging? Page 34.
Yes, sir. And the act segment you mentioned at page 35. This notification is made under the provision of section 4 of the Act 15. This is not after the 2013 act.
Yes, has to be set aside. The instant writ petition has been filed challenging the acquisition proceedings initiated by the communication dated by the notification dated 17/11/2014. As well as the subsequent notification under section 6 of subsequent declaration made under section 6 of the Land Acquisition Act dated 17/5/2017. The learned counsel appearing on behalf of the petitioner has drawn the attention of this court to the notification of the central government dated 19/12/2013, whereby the right to fair compensation was brought into effect with effect from 1/1/2014. Taking into account the above, it is relevant to take note of that the impugned notification dated 17/4/11/2014 and the subsequent declaration on 17/5/2017 under section 4 of the Land Acquisition Act 1894, as well as section 6 of the Land Acquisition Act 1894 could not have been issued in view of section New Act section 120 or 112 114 of the Act of 2002. Accordingly, the notification dated 17/4/11/2014 as well as the declaration dated 17/5/2017 are set aside and quashed. Any steps taken on the basis of the said notifications therefore stands nullified. It is, however, made clear that the nullification, that the setting aside of the said notification dated 17/11/2014 and the notification declaration dated 17/5/2017 and the nullification of any proceedings done initiated on the basis thereof shall not preclude the respondents to initiate acquisition proceedings as per, if deemed necessary, as per the extent provisions law.
Then,
Huh?
But nothing else is still. He expired in 11 January 2023, and the final file.
Writ in the nature shall not be issued setting aside and quashing the impugned order dated in month, directing the prisoner to close and shift his own affairs. Yes, have you informed your client about this thing?
Yes.
When?
I see another, I showed you.
Who is Aishwar? Has he entered into appearance? Then please do this thing. Then you are appearing for?
But the Exide Department, but Council, Gogo is on his legs and would, well,
And you are,
put a private from the point out,
who are you? You are the complainants. Huh? At your behest, they have been, this order has been passed. Yes. Now it is running.
it's running, there's an immediate order, they're running it.
Now she says that she has no contact. Your senior has no contact. But Mr. I. Chaudhary, has he filed his wakalatnama? Yes. Where is he? Huh? Or he does not find it important to appear here? The file is not with him. File is with whom? And B. Dekha is dead. Then did he take the file along with him? Huh? Then what to do? Or it's an interim order. Your client is now selling in a residential accommodation area.
What the complaint has to say.
Now, you also admit it.
So we have done a verification.
So therefore you have passed an order.
Yes, about. After complete the pass out.
Anyways, Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the file, that the instant file could not be traced, and as such seeks for an accommodation. Mr. Gogoi, you have a copy of the writ petition. There's only a writ petition, there's nothing more than that. Give him a copy of it. Take a copy, that is the only file. Mr. R. Gogoi, appearing on behalf of the Excise Department, submits that there is a stay order operating. Mr. Appearing on behalf of the private respondents, submits that in view of the stay order, the said private respondents are suffering. Taking into account the above, list the matter again on 29th of September 2023. The interim order passed earlier shall dated 25/4/2018 is only extended till the next date. Madam, take a copy. Give a copy. That is the only file. And why haven't you filed affidavits?
Matter is basically factual dispute of logic because the private respondent complaints are saying that that signature has been frauded. And that's, and
Don't you think an affidavit is required? So in the meantime, the respondents shall file the affidavit by 27th of September. Short affidavit, whatever you
All right, sir.
and you want to be a party out there and you have not filed an affidavit. Why? File your affidavit.
All right, sir.
Well. Why? The council appeared, Mr. What's your name?
Yes. Yes.
Mr. ACT, the learned council appearing on behalf of the petitioners. Learned council submits that the respondents, that the petitioners have taken back the file from the petitioners on
I think last year,
sometime in the year 2022. Taking into account the above, let this matter be listed again on 27th of September 2023. It is made clear if the petitioners are not represented, this court shall dismiss the petition and they shall pass consequential orders. 15. Yes. Yes.
by this order, by land settlement proposal, which is approved by the pilot, public development land and capture. Subsequently, my lord, from this, my lord, of land on my lord, land approval order.
Only the said and portion of the prosecuted against him. You are in occupation of reserve land, reserve forest.
Not forest land, my lord. Not reserved forest land. My
What?
lord, the land was reserved for my market, my lord. Not the forest land.
The land was reserved for the market
Market.
and the market has now been allotted.
No, my lord. Private, my lord, as per my lord, they did a process to and then the land with some private person. Initially, my lord, some parts of the, my lord, center is to be my land, my lord. And some, my lord, alternate took place, my lord. I have lost them back, due to convicted. And there are approach, we go to the honorable court, my lord. This honorable court, that order, but the time is 70, my lord. Directly the deputy commissioner to pass my lord,
Yes, madam. Huh? Read the page 75 order. Let us hear it aloud. What do you mean? And I don't also understand. Yours, Deputy Commissioner. And the Deputy Commissioner is not represented by anybody. Oh, very well. We will ask this Deputy Commissioner to be personally present then. Yes, read it. Read the order. In pursuance to the order passed by this court, hearing was made between the respondent Joyanta Dutta and Small Traders Association of Bhukwakhana. As per statement of Joyanta Dutta. What is this? You understand in language? But the Deputy Commissioner does not know how to write English. As per statement of Joyanta Dutta, what statement? Peruse the report submitted by circular, and it is seen that the total 36 bears stands in the name of Jugen Dutta. Oh,
So far, there, land is for my lord. There is my lord, really, yeah, but
so
I am entitled my lord, as per my lord, land policy in town area, my lord.
how?
If any, my lord, if, also that land is in rural areas, my lord. No land in the town area, my lord.
Read. Let us read 14.3.
Yes, 40.63.
Three.
And in this case, as person who has land in rural areas of this state, but has no land in city or town in his name or in the name of any member of his family, that has been in occupation of government land with members of the family for last 15 years or more.
Then below that,
And in this individual person who has no land in rural areas or in city or town in the state, whether in his name or in the name of any member of his family, and has been staying in urban area for last 15 years or more with the members of his family.
then 3 bighas. Where is that? There is one mention out there. 14 point, yes, 14.4.
Since,
However, in view of the land policy 1989 and other government decisions prior to adoption of this land policy, the case of indigenous landless people, if found eligible and who have been under continuous occupation of government land since or prior to 28th of June 2001, may be considered for settlement of 1 kata 5 letters of land in case of Guwahati and 1 kata 10 letters of land in case of other towns as one-time settlement measure for homestead purpose if they apply for it, irrespective of having land in rural subject to realization of premium. Then, provided that persons having more than 3.5 bighas in rural will, however, be not entitled to the above benefit. Then,
my lord, I think that there would be of 19, my lord.
19. We are concerned with 19.
But my lord, my land settlement approval is of 2008.
That is no longer there. As of now, it is not there. Now, can this court revert back to that page?
No, my lord. My approval was of the year 2008, my lord. That was my considered on the basis of
Understood, but this has been cancelled now. As of now, can you get the settlement?
1 kata 2 letters, my lord.
Can you get if you have rural area land? As of now, you will be asking for a settlement,
I am challenging my
and
lord.
this court can at best pass an order for consideration as per the extent policy. There is 2 days policy. Now, can you get it?
My lord, my submission is that, my lord, simply, my lord, approval has been given in the year 2008, my lord, and the same has been cancelled by the deputy commissioner, but that order has been challenged by the petitioner before this honorable court by way of the state enforcement.
But in the meantime, things have changed.
But those things has changed, my lord, but my case has been considered on the basis of the.
But,
79, my
but
lord.
if this court would not issue a writ in the nature of certiorari just for the sake of us issuing it, taking into account that the present land policy does not permit you.
But my case was considered on the basis of the, my lord.
Understood then, but can it now be given a settlement? You will be given a
My
settlement.
settlement was already there, my lord, but.
Then if your settlement, are you saying your settlement has been cancelled?
Cannot stand, my lord.
Is your allotment cancelled?
My lord.
Where is the allotment?
No, not the allotment.
Then it's an only an approval. It has to go, after the approval, it has to be sent by the DC to the state government. And after the government will give an approval allotment, and then you will be issued the settlement. And what is your right? As of now, nothing has happened. You don't have an enforceable right. And why should this court now set aside, taking into account that you have 36 bighas of land?
No, that is included.
So what? So we, now in view of the land policy presently, can this court give it? No, can't give it.
Can also take care of any date of the matter. If you want next week, matter to do, I will set up my. Next week, matter, I will get my.
Upon the matter being taken up, none has appeared on behalf of the deputy commissioner. Not Lokhimpur. In spite of have appeared on behalf of the deputy commissioner Lokhimpur to defend the order dated 29/3/2018. The Mr. R. Sharma on the other hand, Ms. P. R. Mohanta appears on behalf of the Revenue Department and submits that the petitioner's allotment, petitioner is yet to be granted a settlement and as such has no enforceable right. The Learned Counsel for the Revenue further drawing the attention of this court to the proviso to clause 14.4 of the land policy of 2019 submits that as the petitioner and his family members has 36 bighas, 1 katha, 3 lechas of land, rural lands. The petitioner cannot be granted any allotment in the town, in towns. Mr. R. Sharma submits that he would take appropriate instructions in the matter. Place the matter again on 29th of September 2023.
16.
Madam, better don't say anything. When I have asked you, no, none of you are present. You want this court should also record that this court accepts the displeasure? No. Please don't say. Yes. To hand over the possession of the lands and properties of so and so, including SB Row Estate, to the petitioners and other co-sharers, being legal heirs of remand as per the decree dated so and so. So there's a decree in your favor. Why you are not going for execution?
Execution of the pending is last, as it is the last notice of the pending is number 10. This is the last communication from the deputy commissioner. Already mutated in our name, only possession is concerned now. They are
That
not
all
given
the legal
possession.
heirs of so and so state.
Due to the consent.
The above orders of Honorable High Court will be start to implement in the first week of Iman and almost all the officers in the house.
After that, now the possession is the only concern. It's already meeting.
No, why are you asking where's the decree for possession? Show me the decree for possession. Where is the decree for possession?
I put order of 235.
Where? Page?
It's the direct, page number 71, 2005.
Yeah. What is it? In view of the order is quoted, this way is disposed of with the direction to the petitioner and the respondents to approve the deputy for carrying out the aforesaid order. What is that order?
Then again, page number 65 also,
Page
65.
65. Yes, what is it?
This is also order passed by this honorable court, but it acts on the basis of the.
Now, where is the decree for delivery of possession?
The last order was.
No. Mister. Must have filed some suit.
Yes.
The suit must have been decreed in your favor.
I will analyze this order.
Yes, where is it? This one.
From page number 30. It addresses from
Let us so in the conclusion, it is declared that the plaintiff is entitled to get the property mentioned in the plaint along with the persons mentioned in Annexure A. The share of the plaintiff of the year would be only, and the defendants are directed to hand over possession of the same to the plaintiff along with others in compliance with the judgment and order passed by this court in so and so. So this order is there. Why it has not been executed?
Thereafter, the government filed an appeal that was
Understood, but why you are not going for execution?
execution is pending.
Then Why should this court,
That's what the last.
no, understood, why should this court exercise 226 here? Tell me.
Filing is the last order.
Yes.
Last order.
MD Borar, State Government Council appearing on behalf shall obtain instruction as the present status of the title suit number is stated to be pending in the execution.
They have to file everything.
Not necessary, but I'm asking you, why should this court entertain the writ?
That's all. They get started or can do or it takes to 5 years. I obtain the instruction in
No, but the thing is, are you saying that the executing court, then are you saying that in all matters where execution can be done against the state government, you are going to file writs?
court direction, the honorable court directed, the last order.
Has this court directed to hand over the possession to you? Where?
Last order.
Yes, where is it?
Page number 73, give the order for the direction to the petitioner and the number 4 to approach the deputy commissioner for carrying out the appropriate order.
What order?
The party shall be approached.
What order? Because otherwise, if we start this, every time it will start. Who is appearing for the deputy commissioner? Yeah, why you have not handed over? Why you have not handed over the position? There is a decree of the court. Is the deputy commissioner above the decree of the court? Tell us, we'll record it. Forget about that. There is the decree of the court. You have filed an appeal against that. That appeal has already gone for a 6. Nothing has happened. Now there is a direction, there is a decree to hand over the possession. Why you have not handed over? This court on 1/12/2020 directed you to file an affidavit. Why you have not filed an affidavit?
We have received an instruction from circle officer, but it is not sufficient or had no comment. Deputy commissioner instruction is not received.
Which deputy commissioner is this?
Next time,
For him to appear.
1 week then I will take instruction.
Monday, why he has not yet handed over the position? Nothing else. Monday. Or Monday, else no instruction, we'll pass another order for his personal appearance. We'll put a guideline out there so that he can come home. This is not done, madam. 2020, this is happening and nothing has been done. The instant petition has been filed, being agreed by the actions of the Deputy Commissioner Karimganj in not adhering to the decree, the decree passed by this court, by the civil court, to hand over the possession of the land, although the record of rights have been duly corrected in favor of the petitioners. This court, by an order dated 1/12/2020, directed the State Council appearing for the respondent number 3 and 4 to obtain instructions as regards the present status of title execution case number 15/2005, pending before the Munsif number 1 Karimganj, and further directed the state respondents to file their affidavit. Almost 3 years have passed by the state government, by the state respondents, and more particularly the Deputy Commissioner Karimganj, have chose not to file any reply. And as per the submission made by the Learned Counsel for the petitioner, the possession has not yet been handed over. Have it been handed over? So, under such circumstances, this court fixes this matter on 25th of September 2023. On which date the Learned Counsel, appearing on behalf of the Deputy Commissioner, Mrs. S. Borua, shall obtain the necessary instructions from the Deputy Commissioner in respect to the incident matter. It is made clear that if the instructions are not given, this court shall pass appropriate consequential orders for the personal appearance of the Deputy Commissioner on such date as deemed fit.
24.
The Learned Counsel appearing on behalf of the petitioner shall also apprise this court on 25th of September 2023 as to what is the status of the execution proceedings so filed pending before the trial court executing. Get your instructions, else I'm going to dismiss it.
In this case, the petition refers to the matter. Seeking executive instruction execute the matter related to Karimganj Valley. It is further pending before another export. The order restriction is granted by the state, different state. And until any such action, body of the executive and because in that case, minor, the SLC is pending minor. If there are total 3 claims in their minor. One thing is related to free. Second thing is related to relating. Third thing is related to many of money. But all these things are pending before the government. Now the kind of creating is minor.
Yes.
The last order I have to few years back, this matter is somewhat similar to one Learned Counsel Mr. Ego is making, but substantially added matter on earlier opinion.
Which
Now,
one?
It is regarding power of the single country.
Now, here the theory is my that the family should be restrained from deciding the matters pertaining to family trust.
Because the matter is pending for the.
Now, my instruction is clear that even the dealings with the SLP, ensure family charge is not pending for the unlimited school. What has actually happened now? 3 MFAs, basically decided by the Honorable Court by common judge. In those appeals, 3 issues were involved. Only number one issue was Number two, whether the correct distance was calculated for charging the freight. And the third issue of terminal charge. Now, the first two issues were decided against the railway. The issue regarding freight incentive and the correct charging is decided. The third issue regarding terminal charge was decreed in favor of the railway. Now, being agreed, by the decision in the first two issues, railway has filed.
They have not filed appeal.
There are total three appeals. One appeal which is MSA number 72 of 2014. In that appeal, they have referred this order.
Where is that?
I have selected judgment of the Honorable Justice Surana Minor in my additional affidavit.
No. Forget about that. I'm asking you, where is your appeal?
Page 21,
No, where is your appeal? Your appeal is where? No, the SLP copy is of Union of India.
Yes, but they
I'm asking you about your appeal. Where is the appeal pending? Because the terminal charges have gone in their favor. Nobody has challenged it. So, where is it? Where is it? Why you are not bringing that into before this court? Where?
Section 1 minus 141.
Additional affidavit. Yes, where page?
Page 141 is the operating. And
Page 141? Ah, yes,
section 1.
yes.
Sir, let me ask the-
Madam, are you understanding what I'm asking you? I am asking you, where is your appeal before the apex? Have you prepared an appeal or not?
No,
You have
but
not.
my case has been filed in my supervisor. Why are you telling that all this?
No. As regard the terminal charges has gone in favor of the,
What comes on the non-provider.
show me.
Para 5 is the claim for the payment minor.
Yes, claim for freight incentive, freight overcharge, and for terminal charge and destination terminal charge. Okay, so 8,88,000 and 24,000. Now let's see what the court has done. Now let me see what the court has done as regarded 36. 36, yes. Ah,
Are not entitled to any relief. However, in MSC number 72, which is my appeal minor, the appellant claimants are entitled to their appeal as well as their claim before the Honorable RCT being allowed. Insofar as
where is the issue number B? B, to what relief or relief the parties are entitled to? Whether the present set of appeals are hit by the principle of res judicata or constructive res judicata in view of the previous judgment and order passed by this court in MFA so and so and so and so. And to what relief? Who has filed that appeal? Mahesh Enterprise. MFA. Who has filed this MFA? 67. Union of India. Then okay, now in 72, what did you challenge? Who has imposed, was the terminal charges imposed by the railways set aside by the railway tribunal?
No, but it has been set aside by the Honorable High Court.
And let us first agree. So the terminal charges which were imposed by the railways was not set aside by the tribunal. You challenged the terminal charges before this vote? In, let us see, 72. The appeal arises out of claim. In this case, the claimants have made their claims under the following heads: claim of freight so and so, claim of so and so, claim of account of originating terminal charges is rupees 50,000. Yeah, so this 50,000. Okay, now let us see what does the score do. Where is the findings? Terminal charges. I am asking you, where is the finding? If you are relying upon the judgment, you should be knowing it. As regard the terminal charges.
The findings of the honorable court starts from para 34. Required MSA 72 is also madam. It is general finding.
Where is that issue? No. No decision.
Not by the.
So, and it was remanded back.
Money back for what?
So then,
They have filed.
regarding terminal charge,
One particle of 2018, which I have added with my additional identifier. And let me tell you.
and in fact, the appeal pending before the apex court in respect to MFA number 72 of 2014 has now become infructuous in view of remanding and this subsequent dismissal.
Probably the SLP is not against 72.
It is there. And 72 is there, arising out of the final judgment and order dated soon.
Common judgment. Where actually implies that we can 57
Let us see the prayer in SLP, the reliefs. Huh? Page, these are grounds for interim relief and the main prayer. Set aside the judgment, so and so and so and so. But the terminal charge is not the question of the. Has not been decided. No issue of terminal charge, but it was remanded back.
only for the calculation part. So far as the right to levy the charge, that was not there. There was some mistake with the calculation. So to that extent, it was remanded.
The instant writ petition had been filed by the petitioners, seeking a direction upon the respondent authorities to keep the matter pertaining to levy of terminal charges. For keeping the matters pertaining to levy of related to the issue of levy of terminal charges pending till the final decision of the Supreme Court in special leave to appeal bracket C number 2920-29212/2018. The learned counsel appearing on behalf of the petitioner submit that the issue pertaining to terminal charge, the issue as to whether the railway authorities could impose the terminal charge is pending adjudication before the Supreme Court in the above mentioned special leave to appeal. And as such, the railway tribunal at Guwahati be directed not to decide any of the matters wherein the issue of terminal charge is pending, arises, pending disposal of the special leave to appeal before the Supreme Court. This court have duly taken note of the order, the judgment and order dated 23/2/2018. The common judgment and order dated 23/2/2018, passed in MFA number 67/2014, comma, MFA number 72 of 2014 and MFA number 68 of 2014. From a perusal of the said judgment, it transpires that in MFA number 67 of 2014, the claim petition filed before the Railway Tribunal related to a claim on account of freight incentive of rupees 74,58,636. B, freight overcharge on charging of excessive distance of rupees 11,88,377. C, claim on account of originating terminal charge of rupees 8,88,150. And D, destination terminal charge of rupees 24,920, totaling to 93,12,581. In MFA number 68 of 2014, the claim relates to a claim on account of freight incentive of rupees 41,72,119. B, overcharge on charging of excessive distance of rupees 2,42,613. C, claim on account of originating terminal charge of rupees 7,51,410. In MFA number 72 of 2014, the claim related to a claim on account of freight incentive of rupees 45,12,305. B, freight overcharges on charging of excessive distance of rupees 2,66,076. C, claim on account of originating terminal charges of rupees 50,480. It is seen that the MFA number 67 and 68, MFA number 67 of 2014 and MFA number 68 of 2014 was filed by the railway authorities, whereas MFA number 72 of 2014 was filed by the claimant. In the original claim, which had originated in terms with MFA number 67 of 2014 and MFA number 68 of 2014, the Railway Tribunal did not grant the claim on account of terminal charges.
Permitted probably have understood the German paragraph 33 and 36. It indicates that the point number A and B were decided against the lady. So C and D was not interpreted. A and B was with regard to incentive and charge. Certificate, the point first point of determination commission is decided in the affirmative and in favor of the claimants and against their claim. In 36, it says the point of determination is decided in favor of the claimant and against the claim. These two issues, so we are agreed by this.
No, it's okay. So the claim, in the originating claim of 67 AF, the Railways Tribunal did not grant the terminal charges. However, in MFA number 72/2014, why it was challenged is not known. It was the contention that the claimant was a new customer. In MFA number 72/2014, which arises out of the claim and the appeal filed by the claimant, it was an admitted fact that the claimant was a new customer. In the MFA 72/2014 was filed by the claimant, and the said claim was dismissed, was rejected in toto.
72. Well, that was allowed. So far as
The claim made therein was
by the time.
rejected in toto. And as such, MFA 72/2014 was filed by the claimant. This court found that the order of rejecting the claim of the petitioner or of the claimant in MFA number of the appellant in MFA number 72/2014 was not sustainable, and as such allowed the appeal and remanded the matter back to the Railway Tribunal for fresh adjudication. from a perusal of the entire judgment, in dated common judgment, an order dated 23/2/2018, there is nothing which would show that this court had adjudicated the rights of the railway authorities to impose terminal charges. And as such, Mr. B. Sharma, the learned counsel appearing on behalf of the railway, submits on instructions and with the authority that in the SLP bearing number, here number 2 the issue of imposition of terminal charge is not in question.
Not in question. That is what I have understood.
Taking into account the common judgment and order dated so and so in MFA number 68 of 2014, 69 of 67, 68 and 72 of 2014. And the issue of terminal charge being not a subject matter of consideration in the SLP bearing number so and so. The question of issuance of a writ upon the Railway Tribunal, RCT, Railway Claims Tribunal, Guwahati, not to adjudicate any claims pertaining to wherein issues arise pertaining to terminal charges on account of the pendency of SLP number so and so, does not arise. Accordingly, they instead this court but not file any merit in the petition for which the petition stands dismissed.
It is the main restriction. I have taken, the restaurant number 8 to 17.
Mr. Mohanto, in this matter, you have filed an objection that they are not entitled to that amount. It is a case of apportionment.
Apportionment as well as whether there was a bona fide transfer and they have forfeited the right. Those should be decided. And the deputy commissioner should take the call.
No. The deputy commissioner cannot take the call. The call has to be taken, referred to the court.
The only for apportionment if there is a dispute. Really apportionment,
As regards any amount,
any amount fixation or apportionment, that will definitely can be referred to the court. But here, there are further questions to be decided by deputy commissioner.
what?
Whether the surrender, let us take it, under the law, surrender could be approved subsequently also, effectively, that initially when they have surrendered, relinquished by executing registered relinquishment deeds from 10, 11 years back. And the allegation is that the land has already changed the character because those have become non-agricultural land by this time because of the rapid industrialization or the township. Therefore, they were not in cultivation. Nothing. They surrendered in favor of the original owner, whereupon I personally believe. Therefore, my tenure also there was, I think, long 10, 11 years more. Thereafter, when the compensation comes, they have come up now. Well, fine. If they are entitled, definitely. But the authority didn't decide the objection. Simply, my objection was filed, authority passed the order without hearing me. That
No,
is
the-
the grievance, basically.
but tell me, can the authority decide
Yes,
Yes.
well, the
No.
commissioner can decide,
No,
not regarding the amount.
not, it is not only the question, no. Mr. Monta, it is not only the question of the amount. It is a question of apportionment or whether you are entitled to at all,
Yes,
whether they are person interested or not. Can the deputy commissioner decide? No, it is there. If there is no dispute, then it is a different
what
aspect.
I find, my lord, under the Appointees Organization Tendency Act, the right has been given to the deputy commissioner. That is my answer. Right has been given to the deputy commissioner.
But that is not the matter before the deputy commissioner. The deputy commissioner exercises the power out here as a collector.
They are connected.
They cannot decide that. Then you have to go to the Board of Revenue for other aspects,
No.
or the deputy commissioner for cancellation of their rights for another aspect, which is absolutely a different aspect.
Then in that case, what has fallen from your lordship? If the deputy commissioner has just passed an order as a collector under the acquisition act, then of course, all these questions, whether the apportionment, right to get, all these things will come.
The moment you have filed that objection, the deputy commissioner ought to have referred it to the district court.
District court.
That's all.
In that case, the reference court will have to take the call.
Absolutely.
And then all these questions will come up. So lordship may have to keep it open, because what I find.
No, that I am keeping it.
Commissioner, otherwise is the authority under the temporary complaint.
So if there is any objection, the deputy commissioner wants to give certain amount of money to these people, the riots. Okay, you are objecting to it, saying that you cannot. Therefore, the question arises as regards whether they are entitled or not.
Right.
This cannot be decided by the deputy commissioner. The deputy commissioner has, the moment you have filed the objection, has to refer it to the court.
Under the.
Land acquisition act.
Land acquisition. That is the correct proposition.
Yes. So that is the only way, because there the question. So the moment you have filed the objection, the deputy commissioner, that passing of that order is wrong. So that order has to be set aside, which you are impugning, and thereby directing the deputy commissioner to make the reference.
And then all the questions will be decided by.
Everything will be decided there.
That-
Because otherwise, keeping this matter pending out here is, because both of you are at loss.
That is true. Otherwise, it has not come before.
A land acquisition act. This is none other than 1894,
1894.
not the 64.
No.
Who is appearing for the deputy commissioner? Is this done under the 64 Act or the 1894? That was done for this thing, huh? The acquisition,
For IIT,
IIT, so it will be done 1894. This was done in 2000.
2000.
You have challenged it. LA case of 2012. So this will be done under the 1894. 1894. IA, Mr. Monto, let me allow the IA, make them also parties. The instant application has been filed by the applicants who claims to be the legal representatives of whom?
Of this guy.
Huh?
Of this guy.
Who?
Father name is Shon Mehta. Their father was the Rayot brother. And some are already my party, some brother, sister, but his 5% was the their party.
How? Show me who are the persons, 18, 19, 20, 21. Where is it?
So Shiva is 5 money.
Huh?
Is 5. 5. The Buddhist. Son of Indian Buddhist.
The instant application has been filed by the applicants who claims to be the legal representatives of the riots of the occupancy riots. Who were in occupancy rights in respect to the land acquired in LA case number 11/2012. It is the case of the applicants that they ought to have been made parties to the instant proceedings, as they are also persons interested. Mr. K.K. Monton, the learned senior counsel appearing on behalf of the petitioner, though does not object to the arraying of the said applicants as respondents to the instant petition, but submits that the predecessor in interest of the applicants had no right over the land. Taking into account the above, this court includes the respondent, the applicants number 1 to 5 as respondent numbers 18, 19, 20, 21, and 22 to the writ petition. The registry is directed to make necessary correction of the records on the basis of the instant order and also upload in the CIS. IA accordingly stands disposed. According to the main condition. The instant writ petition has been filed challenging the order dated 17/10/2017 passed by the Deputy Commissioner Kamru Aminga. Huh? What is the date of the order? 17/10/2020, passed by the learned Deputy Commissioner, Kamru Aminga, whereby the Deputy Commissioner passed an order that the riots would also be entitled to a part of the compensation. In respect to LA case number 11/2012. Next. The facts involved in the instant case, in brief, are that one Jagadhar Chaudhary and Hemadhar Chaudhary were the original owners and patadas of agricultural land measuring 19 bighas, 3 kathas, 6 lessers, covered by Dag number 108 and 109 of NK Pata number 6 of Moliata Revenue Village under Polaspuri Revenue Circle in the district of Kamrup, Assam. The petitioner purchased the said land by the registered deed of sale bearing deed number is there, 5220, dated 31/3/2008. Thereupon, the petitioner's name was duly mutated in the land revenue records as owner, patada, and possessor of the land, replacing the respondent number 5 and 6, who were the original owners. It is the further case of the petitioners that the respondent number 5, 6, and 7, the case of the petitioners, that there were 7 occupancy tenants who were cultivating their lands earlier under the respondent number 5 and 6. And they were being issued the Khotian number 43. Subsequent to the change of the character of the land, and as the land became not suitable for agricultural purposes, there was no further cultivation over the said land by the said occupancy tenants. It is the further case of the petitioner that the respondent number 7 had executed a deed of relinquishment in favor of the respondent number 5 and 6. Whereby the possession of 7 bighas out of 20 bighas of land covered by Dag number 108 of Pata number 6, bracket by Khotian number 43, situated at village Moliata, Moza Soyani, Circle Officer Polaspuri, was handed over to the respondent number 5 and 6. This deed of relinquishment was executed on this registered deed of relinquishment was executed on 16/2/2008. And thereupon, the petitioner purchased the said land by the registered deed of sale bearing deed number 5220/2008, dated 3/4/2008. It is the further case of the petitioner that the respondent number 9 to 12, that the respondent numbers 8, and 9 to 12 have also executed similar deeds of relinquishments. And as such, and 8, 9 to 12, 13 to 17 have all executed deeds of relinquishment in favor of the respondent number 5 and 6. And thereupon, the respondent number 5 and 6 by various deeds of sale bearing deed numbers 5370/2008 dated 5/4/2008, deed number 5426/2008 dated 7/4/2008, and deed number 5281/2008 dated 4/4/2008 transferred such the said lands contained therein, mentioned therein, to the petitioners. I mentioned it, 5370, I mentioned. These lands have also been mutated in the name of the petitioner. Next. In the backdrop of the above, this court further finds it relevant to take into account the dispute involved herein. The respondent number 3, a land acquisition proceedings was initiated for acquisition of land measuring 19 bighas, 3 kathas, 6 lechas for establishment of the IIT at village Maliata under Polasbari Revenue Circle. The said case, said land acquisition proceedings, as per the petitioner and the counsel appearing on behalf of the Deputy Commissioner, was done so in terms with the provisions of the Land Acquisition Act 1894. After the inquiry so conducted by the Deputy Commissioner, the petitioner received a notice dated 3/6/2017 issued by the respondent number 3 regarding the payment of compensation of land in the same notice. It was mentioned that 1/4 of the said compensation shall be paid to the tenants, to the 7 number of tenants whose names were recorded as per the report of the respondent number 4. Under such circumstances, the petitioner submitted objections to the Deputy Commissioner Land Acquisition Branch on 8/6/2016, which was followed by another objection dated 15/6/2016, objecting to the payment of any part of the compensation to the tenants on the ground that the tenants have already relinquished their rights over the land in question. Further to that, the petitioner had also issued another communication to the additional Deputy Commissioner (LA) Land Acquisition Branch on 19/6/2017, requesting that the said payment should not be made to the tenants, 7 tenants as they have already relinquished their rights in favor of the necessary in interest of the petitioners. That is the response number 5 and 6. In spite of the state objections being filed, the Deputy Commissioner, Kamruk Amin Gao, passed the impugned order dated 17/10/2020, whereby it was decided that an amount of 41,87,580 would be paid to the 7 tenants. And the remaining amount would be paid to the petitioner. Mr. Monta, you have received the remaining amount? Huh?
Yes, I'm going to take, probably not.
Okay.
I know that it's definitely discussion. I don't get it.
It is, however, relevant to observe that the total compensation amount it is, however, relevant to mention that as per the said order dated 17/10/2020, the petitioner would be entitled to rupees 1,25,62,740. Mr. Bhuya, are you challenging the quantum? You claim that you are only entitled to 1/4. Huh? That is different. I am not on that. But your right is only 1/4. I've heard the learned counsel, I have perused the materials on record and have also heard the learned counsels for the parties. Mr. K.K. Mohanty, the learned senior counsel, submitted by drawing the reference to the provisions of the Land Acquisition Act and more particularly to Section 18, as well as Section 30. Of the Land Acquisition Act 1894, wherein it has been stipulated that if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector is statutorily bound to refer such dispute to the decision of the court. The learned senior counsel therefore submitted that the Deputy Commissioner on his own could not have passed the said order dated, and as such, the said order is without authority and jurisdiction. The learned counsel, senior counsel further submitted that he has no instructions as to whether the petitioner have already received the amount of rupees 1,25,62,740, which is the 3/4 of the total compensation awarded in respect to the land. Yes, Ms. Yudas, what is your submission?
Here, let us 18 and 21.
Ms. Yuda, the learned counsel appearing on behalf of the Deputy Commissioner, Kamrup Amingam, submit with due fairness that the Deputy Commissioner, instead of passing the impugned order, ought to have referred the matter to the court. That is the court of the district judge, Kamrup Amingam, to adjudicate on the issue pertaining to pertaining to the apportionment of the compensation. Mr. K. Bhuya, the learned counsel appearing on behalf of the private respondents, including the newly impleaded respondents, submits that the same relinquishment deeds are fake and also the remaining I'll take and also have no sanctity in the eyes of law, taking into account that such relinquishments that as per the provisions of the Assam Temporarily Settled Area Tenancy Act 1971, a relinquishment cannot be made by the occupancy tenant in favor of any other person except the government. It is his submission. That is not recorded. It is his submission. It's okay. That is his submission. No, not necessary. The learned counsel, however, the learned counsel for the private respondents, however, submits that the entitlement of the petitioner of the private respondents are limited to 1/4 share of the amount which have been granted by the Deputy Commissioner, Kamrup Metro, Kamrup, by the Deputy Commissioner Kamrup Amingam, by the impugned order. I've heard the learned officer. Upon hearing the learned counsels for the parties, this court finds it relevant to take note of two provisions of the Land Acquisition Act 1894. The first of such provision is Section 18, which stipulates that any person interested who had not accepted the award made by written application to the collector required that a matter be referred by the collector for determination of the court whether his objection to his be to the measurement of the land, the amount of compensation, the persons to whom it is payable, or the apportionment of the compensation amongst the persons interested. This code further finds it. The second provision, which also requires to be taken note of, is section 30, which stipulate of the State Land Acquisition Act of 1894, which stipulates that when the amount of compensation has been settled under section 11, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the decision of the court. This code further finds it relevant to take note of another provision. That is section 31(2) of the Land Acquisition Act 1894, which stipulates that apart from others, that if there be any dispute as to the title to receive the compensation or as to the apportionment of it, the collector shall deposit the amount of the compensation in the court to which a reference under section 18 would be submitted. Now, in the instant case, there is no dispute. The dispute only arises in the instant case. The dispute only arises as to whether the private respondent's hearing would be entitled to 1/4 of the compensation in LA case number 11/2012. Which have been adjudged by the Deputy Commissioner in terms with the impugned order dated so and so. The records further shows that the petitioner immediately on coming to learn from the notice dated 3/6/2000 the petitioner during the inquiry proceedings have submitted objections to the fact that the private respondents or their predecessor in interest could not be entitled to any compensation. Be that as it may, by the notice dated 3/6/2017, the petitioner have been informed that there are 7 recorded tenants and the petitioner was asked to submit the original copies of the relinquishment deeds. The petitioner thereupon, on 19/6/2017, submitted a communication to the additional Deputy Commissioner, Land Acquisition Branch, stating inter alia that the respondent number, that the private respondents or their predecessors shall not be entitled to the 1/4 of the compensation in respect of the land acquired by LA case number 11/2012. It is seen that thereupon the deputy commissioner adjudged that the private respondents and their predecessor in interest would be entitled to 1/4 of the compensation, that is rupees 41,87,580. It is not known from the records as to whether the petitioner thereupon approached the respondent authorities for making a reference under section 18. Inasmuch as the petitioner thereupon immediately approached this court by filing the instant writ petition. So, taking into account that these aspects, taking into account the provisions of section 18 and 30 of the Land Acquisition Act 1894, and the question as to whether the respondents, the private respondents or their predecessor in interest have relinquished their rights or could have relinquished their rights, are questions of facts which can only be adjudicated upon by reference court. Under such circumstances, this court, instead of deciding the said disputes which have arisen in the instant writ petition, grants the liberty to the petitioner to file an application within 30 days. Is the amount of 30 days. Within 30 days, you file an 30 days. I mean, 30 days, yes. Because now that application will be treated as a plain there. 30 days. 30 or 6 weeks. 6 weeks. I give you 6 weeks. No, because the time is 6 weeks. Runs 6 weeks time from today for filing an application seeking reference to the court. The dispute as to whether the private respondents herein would be entitled to 1/4 of the compensation. In respect to LA case number 11/2012. Pusko. Today is, I think today, mistake, na? For the sake of clarity, this court makes it clear that the 6 week would culminate on 2nd of November 2023. This court further observes and directs that if such application is filed within the said period, as about aforesaid, the collector cum deputy commissioner Kamrup Amingaon shall refer the said dispute to the court of the district judge. Amingaon, Kamrup, district judge Kamrup Amingaon, for which First, you have not been released any money. It is also made clear that if the application is not filed within the stipulated period, there shall be no question of referring the dispute to the making a reference in terms with section 18 or 30 of the Land Acquisition Act. And the Deputy Commissioner, Kamrup Metro, Kamrup Rural, shall take effective steps for disbursement of the amount to the private respondents herein. Next.
If at all, I think it's what the party will get as per that. Or-
No. Yours I am giving you now.
Oh,
This goes further, taking into consideration that there is no dispute as regard 3/4 of the compensation. Which, as per the order dated, impugn order dated, is rupees 1,25,62,740. The same be disbursed to the petitioner within 10 days from the 15 days from the date of receipt of the instant certified copy, if not already disbursed. This whether you file or not, you get this 1,25,000,000. That is 340. That I'm coming. Mr. Monto, take your seat. I'm doing it. This court further directs the Deputy Commissioner, Kamrup Metro, that if within the period of that no amount be released to the private respondents till the expiry of the period granted to the petitioner for filing the application seeking reference. If the petitioner files the said application within the time stipulated, the said amount, the Deputy Commissioner, Kamrup Metro, Kamrup Rural, shall, while making the reference under section 19 of the Land Acquisition Act 1894, deposit the said amount to the court of the district judge, Kamrup Rural, in terms with section 31(2) of the Land Acquisition Act, so and so. The said amount, the decision of the district judge, Kamrup Rural, the entitlement in respect to the said amount thereafter shall be subject to such decision of the reference court.
But sure. I vote as per this concern. On the one hand, we vote cannot rely on. I have just mean, just number 7 and other religion. Because 5 and 6 are the original.
I have not said 5 and 6. I have said private respondents. Or the respondent numbers, private respondents, it is from 7 to 22. No, 7 to 23. Huh? You give your names.
The include order, this is not 2020, it is 70, 10, 20, 70, only 20 has appeared here. It is also 70.
17, impugn order to 17. Huh?
Yes, it is 70.
ठीक.
No, sir. The order is already given.
এই ওপৰত এনেকে এইখিনিতে মই এইকেইটা লাষ্টৰ খিনিতে কৈ দিওঁ পিছত accordingly the instant repetition stands disposed of with the following observations and directions তাৰ পিছত এইবোৰ লিখি 1 2 3 4 5 6 7 8
I don't know.
yes madam एक मिनट थोड़ी record her name will do it's okay we will look into it whether it has been complied with or not.
Pending item number 5.
Yes, madam. Continue. Yes. Therefore, the instant repetition has been filed by the petitioner. Seeking a direction. Upon the respondent or number 2 to 9, to show cause, the response shall not immediately. Seeking a direction upon the respondent numbers 2 to 9, no. Respondent number 2. 2 to 9. All these people. Why will the others investigate? It will be only the 2, 3 and 2 and 3. That's all. Seeking a direction upon the railway Rongia police station to investigate the case in respect of which GD entry number 516 dated 18/4/2017 and GD entry number 590 dated 24/2017 was registered under sections 447/429/352/506/34 of the Indian Penal Code. It reveals from the records that an affidavit in opposition has been filed by the Superintendent of Police Aminggaon, wherein it has been mentioned that on 18/4/2017, the petitioner lodged an FIR at Rongia police station, and after receipt of the FIR, Rongia PS case number 166/2017 under section 447/427/379/352 /506/34 of the Indian Penal Code was registered and investigated into. It has also been mentioned that Rongia PS case number 166/2017 corresponds to GD entry number 516 dated 18/4/2017. It is also stated that various steps were taken for the purpose of investigation of this case, and due to the non-cooperation of the petitioner, the progress in the investigation of the case could not be made. Further to that, it was stated that on 24/2017, another FIR was submitted at Rongia PS case police station, stating the same facts as stated in the FIR dated 18/4/2017. The same FIR, the contents of the said FIR dated 24/2017 was entered in GDE by number 590 dated 24/2017 and was entrusted for investigation. This court further finds it relevant to take note of that in respect to Rongia PS case number 166/2017, registered under section 447/427/379/352/506/34 Indian Penal Code, the investigating officer of Rongia Police Station had submitted its final report by Rongia PS FR number 367/2000/22 on dated 31/7/2022 before the court of the learned court of the SDJM Rongia. This aspect of the matter could be seen from the instruction placed by Ms. U Das, the learned additional senior government advocate, from the instruction dated 29/2023 placed by Ms. U Das, the learned additional senior government advocate. The said instruction is kept on record and marked with the letter X. Taking into account the above, it is the opinion of this court that as the FR final report have already been submitted in Rongia PS case number 166/2017, nothing is further required to be adjudicated upon in the instant proceedings. The petitioner would be at liberty to take such appropriate steps as provided under the Code of Criminal Procedure of 1973, if agreed by the final report so submitted in respect to Rongia PS case number 166/2017. With the above, the instant petition stands closed.
$25.
Bye-bye. Huh? Who is senior counsel? Huh? You have obtained a stay. Stay. No stay. That is more than stay. Where is that? 2019, no coercive action then? It is agreed by a communication dated issued by the superintendent whereby the petitioner has been directed to deposit an amount which is alleged to be the loss caused to the checker by destruction of so and so of doubtful beer. So, then affidavit filed.
Yes, sir.
Huh?
Takeover was also supposed to appear, but he has some personal difficulty. But Lordship, I have been told that there is a similar matter before the Lordship court on 9th October. Where a similar issue about levi of excise duty on this particular. item.
Dead stock. Dead stock.
Yes, Lordship, these parties.
Released the matter on 9th of October 2023. The interim order passed earlier shall continue till then.
Okay.
Mana sudai punya punya apa dua tu. Dalam nonton boleh lagi tu.
Where is the land? Madam, where is the land? District, rural. Have you been settled with the land?
It was already purchased by my friends
How?
by a registered.
Where is that? Let us see item number 20. Where is that registered deed? Hmm? We have purchased this land. Where's the patta? No, madam. What did you purchase?
Years back from period purchase a plot of land that is too big in the district of.
Madam, we are not concerned. You kindly come to annexure 2. No, maybe. What is annexure 2?
Dasipara Town Committee, principal of the.
We are referring to which repetition? 8657. Yes, show me the cell list.
And it's a from Jagalula and Sayadura.
What did you purchase?
Four Tata 18 of 10. Serial number 4, that number 70 is part 3. Schedule and boundary.
Where is the patta?
That is annexure 1. Serial number 4. So, serial person is a partner of. As per Gopal Financial, the written says Katyan.
With the Khatian is being issued in respect of any person, means the no patta issued.
Subsequently, they named it as Patta. After 2010, 12.
So this is done under the Gwalpara. Let's see that provision. From Gwalpara to Nilsai. Where do we get that? Number 2. Where do we find that act?
105, 103. Provisions are written in annexure 1, page 13 in the Katyan itself. Gopal Financial, 29.
Where is it? Which document you are referring to?
Annexure 1.
Of?
The Katyan.
It's a Khatian. It's in vernacular. Yes. How do one read it?
In the middle portion, it is 105, 103.
You are referring to a document which is not legible. And you are basing your rights on the basis of this document. Said it is no right unless you show. If you are saying that a Khatian can be issued in respect to a it's a Khatian which is being done under the Gwalpara Tenancy Act, then we'll have to look into that. Let's see. Where's the Gwalpara Tenancy Act? Because they specifically claim it to be a government land.
But in the year 1972, they made it a government property.
So I will challenge that.
Thereafter, when we approached them to appeal the revenue from, they denied their.
1972.
We have paid the provision in the.
No. When did they make it a government trust land?
1972.
Then have you challenged that?
But yes, I have challenged that by way of this.
After 50 years.
We have actually came to know later on this. That I have stated.
And you were paying the Tozi Pahari?
Yes.
When?
Already earlier Is that in the year 2010, when the installment will be done, we will convert your land to be a patta land, not as we have a purchase.
That is okay, but I am saying, you are saying that in 1972, this was made a government land. Let's assume that it is okay. When did you, were you paying any revenue in between from then till date?
2009 annexure 3 lordship page 21. 2010 revenue.
Page 21, yes. Then, so prior to that, you did not pay any revenue.
1971, we have purchased and there.
You have never paid the revenue. Whether your name was included, then how can this repetition be at all maintainable in this manner? In 2009 also, the moment you are paying the TOSI, means that it is a government land. You don't pay the TOSI for your land. Then
Then lordship, we have approached and they said that during this government we will convert it.
that is a different thing. That is, did they write and say, or they just told you? Then you fight it against that person concerned.
2010, 11 also, they are taking the.
In,
2017, we filed a representation before
unless you show me that any right is there, because this only shows on regard the tag number 17.
There are 3 plots of land lordship in all these 3 plots of land lordship were converted to government house.
Huh?
3 cases are there, lordship, I understand, and another one is there, lordship. These are all adjacent land lordship. And
These are all.
4 plot of land lordship, they have corrected the patta from patta to government house.
So unless that you are challenging that, have you challenged that?
Yes, lordship, thank
Where have you challenged it here? In this repetition, there is no challenge to that. For conversion, where have you? There shall not be issued directing the respondents to accept the revenue in respect to this, as to why further there should not be issued directing to resettle the scheduled land with the petitioners, since the petitioner have purchased the same in the year 1999 and has been possessing the same. Is this the prayer? You are not challenging the conversion of the into a government land.
you.
No, have you challenged it? Or should we believe, should we accept it, it is, or read it in between the lines? That too, when you have put it in a spacing of 1.5. There is no case. Let's,
1971, we are residing there, lordship.
you are residing out there, but you are asking for a plot of land which is far exceeds now.
Lordship, how they have made it government house, there was some.
You are not challenging it.
They have not found any notice to the.
When they have done or not, whether you have, whether it was done or not, what right has accrued upon you, on the basis of that, you have to show me that that was a plot of land which was there, in which you had a right accrued on the basis of the deed of sale. You are referring to the 1877 Act, the Gwalpara tenancy. Madam, what case? Okay. Think about it after puja. Anyway, the revenue doesn't want to evict. So, why not issue rule? You don't want to evict them. Let it come up after 15 years. Then The matters after the Puja vacations. Hmm? 25 till
20 to 23.
is that a series? How many minutes?
20 to 23. 26 and 27.
Yes. A judgment, you're liable to pay.
Yes, yes.
Then what happened? Have you filed an appeal?
So. Regarding my, only that, I have some fancy, debt of my, contribution for.
This is the case of the only establishment charges. Then why you're bringing the debt stock? Establishment charge is different. Establishment charge is for the people who are standing out there because of you. You are to, they, as per 36/2017, there was this notification by which it will say that within this period, till it is being done, you are doing it, as per clause 9, if I am not wrong. Then they're covered.
I have paid the other debt, the return on for 2018, I think this review audit has been. For 2018.
You have paid all your tax.
2017.
See my judgment. I said if payment of tax has been done, it is not necessary. I made it clear. Tell.
And there are 25 last there are two regarding the debt stock.
The petitioners herein are liable to pay the establishment charges in terms with clause 9 of so and so, terms of Iman, and are not paid. On the basis of the orders passed by the authorities in terms with so and so are not paid, or such amounts so demanded are not set aside in a court. The respondent is given the liberty to take such action as deemed necessary. The respondent number so and so, the Commissioner of Excise is directed to take a definitive decision in respect to the unfit oblique debt stock lying in the warehouse within a period of 2 months from the date of the certified copy of the instant judgment in served upon so and so. The petitioner would be at liberty to submit such materials before it to show that the amounts the petitioners have paid, as well as the observations and finding of the subcommittees, and it's during such period it is found that we have already paid the amounts in terms of the demands so made under so and so. Then from such state, the petitioners have already paid the rate, the petitioner would not be liable for payment of establishment. This court is not to impose any cost. Because both the instant petitions arises have been filed by the petitioners challenging the imposition of establishment charges upon the petitioner. The legal counsel for the petitioner, as well as the legal counsel appearing on behalf of the excise, submits that the issue involved in the instant both the petition stands covered by a judgment of this court dated 9/5/2023 in MS Borak Warehouse Private Limited and another versus the state of Assam and 2 others, WPC number 4575/2021. Taking into account the above, this court therefore disposes of the instant petition with the following observations and directions. 8 paragraph 25 of the 1, 2, 3, and 4. Take it a DD.
Keep it, 28.
Yes, Mr. Sharma, we don't see you now. They decide.
Consumer of the Kisara Job Center, Samway Samiti Government. They are being reduced by the order.
Be set aside in here, withdrawing the order of suspension on the so and so sub full license issued in the name of this. Yes,
Order. And it's very- there's no appropriate action.
Whether respondent number 11, whether committee has now resolved a new committee has from respondent number 11 no longer is secretary.
you are appearing for 9, 10 and 11. Setting aside the impugn order issued, withdrawing the order of suspension under so and so issued in the name of the respondent number 9 and also for quashing the license issued to the respondent number 9. Quashing of the license issued to the respondent number 9. Who is the petitioner here?
This is the consumer fraud.
Huh?
Of the Kisara Government.
You are?
Consumer fraud.
And you want the license to be?
There are certain allegations against the president and secretary of the Samiti Government. So my limited prayer is also direction to the authority to conduct an inquiry and take the necessary action. Because there are a number of allegations against the secretary and president of the Samiti Government.
Where? You file your affidavit then. Mrs. S. Gurva appearing on behalf of the respondent, whom?
1, 2, 4 and 7. 1, 2, 3, 4 and 7.
No, give me someone important, not others. Who has conducted the inquiry? Appearing on behalf of the state respondent submits that that an inquiry has been conducted in respect to the allegations so made by the petitioner. Taking into account the above, this court deems it proper that the said inquiry report be placed on record so that this court as well as the petitioner is aware of the as to what transpired in the said inquiry. That the said inquiry report be placed by way of an affidavit to be filed by who has done the inquiry?
Inspector Food and Civic Supply, Consumer Affairs.
By an authorized officer of the Food and Civil Supplies Department of the Government of Assam. List the matter again on 6th of October. The affidavit be filed by 4th of October. Give your names.
29.
Oh, this one. Huh? So you won't insist upon that. Then we have asked you to take that instruction. What is this telephoning business where this court last time also asked, does it take 20 days for you to get it? Where is it? Where do you have to get the instructions from? Huh? Texas? Then it's Bangagor. GM. During this July month, some people keep on moving by rolling towards the Ghat. They can reach first and get that instruction in that manner also. For you to get that instruction, you are not getting it. 10 days. Simple. Are you happy with your present state of affairs? That's all. Then what is there? This is the matter on 29th of September 2023 on which date Mr. S. Bora appearing on behalf of the GMC or GDD shall obtain the instructions in terms with the order dated 30/8/2023. Oh, you filed the affidavit? You have not received. This is a good thing. That means you are, okay.
So you can see the paragraph.
No, here we will give it on the ground that you have not filed any affidavits in spite of obtaining this court. The petitioner herein,
So there is, paragraph number 5.
what is there?
The paragraph.
That is why I wanted, and you have not, you are not interested to give this. We have given you twice. See, have you looked into my early orders? The revenue department is directed to file an affidavit as to whether a nephew of an unmarried martyr can be considered as a next of kin for the grant of ex gratia of an amount of ₹5 lakhs. That was on 4/8. Then on 28/8/2023, this court had further make it clear that if no evidence has no objection to the grant of the benefit. So I will say this. The instant writ petition has been filed by the nephew of one Mizajur Rahman Barbhuia, who had lost his life on 23/1983, being a victim of the police atrocities during the Assam agitation of 1979-85, and he was declared as a martyr of the Assam agitation of 1979-85, which is reflected in the list of 860 martyrs as published by the government of Assam. It reveals from the records that the government of Assam has a scheme where is that scheme? As a scheme for grant of ex gratia of an amount of ₹5 lakhs to the next of the kin, bracket NOK, of the martyrs of the Assam agitation, that is the scheme dated 10/12/2016. The records of the repetition shows that on 2nd of March 1990, an amount of rupees 30,000 was sanctioned for the purpose of payment to one Soyadur Rahman Borbhuiya, as ex gratia for the martyr Mizazur Rahman Borbhuiya. And the said amount was received subsequent thereto. The scheme that is a home, the scheme, another scheme was issued whereby an amount of rupees 5 lakhs was declared to be the ex gratia to be paid as a token of respect towards the contribution of martyrs in the development of the state. From the further records of the writ petition, it reveals that the circle officer Nodwar, Revenue Circle, Sotia, had submitted an inquiry verification report stating that the petitioner is the next of being the nephew of late Mizazur Rahman, the petitioner is the next of the kin of late Mizazur Rahman. Subsequent thereto, on 5/9/2019, the Joint Secretary to the Government of Assam, implementation of Assam Accord Department, subsequent thereto, the Deputy Commissioner Hunitpur Tejpur had issued a communication to the Joint Secretary to the Government of Assam, implementation of Assam Accord Department, placing the various details to the effect that the petitioner is the next of the kin of Mizazur Rahman Borbhuiya, along with all bank details, etc. Thereupon, on 23rd of October 2019, the Joint Secretary to the Government of Assam, implementation of Assam Accord Department, issued a communication to the President of the Secretary, Assam Martyrs and Victims Aid Trust, to make necessary verification in connection with the ex gratia grant of ₹5 lakhs to the petitioner as the next of the kin of martyr Mizazur Rahman Borbhuiya, who was unmarried. The petitioner thereupon was expecting the said amount to be released, but as nothing was done, a representation was submitted to the Assam Martyrs and Victims Aid Trust on 8/11/2019. However, as nothing was done, the instant petition was filed. This court, by an order dated 27/1/2021, issued notice. The respondents have not filed an affidavit. It is, however, relevant to take note of that this court had specifically directed the Revenue Department of the Government of Assam on 4/8/2023 to file an affidavit whether a nephew of an unmarried martyr can be considered as a next of the kin for grant of ex gratia in terms with the scheme dated 10/12/2016. However, the said affidavit was not filed on the date so fixed, that is on 28/8/2023. Again, when the matter was on 28/8/2023, this court further granted time till today, further granted time to the Revenue Department to file the affidavit. And it was also observed by this court that if no such affidavit is filed, it would be deemed that the Revenue Department had no objection to the grant of the benefits even to the nephew of a martyr. Today, when the matter has been taken up, Mrs. P.R. Mohanta, the learned counsel, appearing on behalf of the Revenue Department, submits that in spite of various communications, the Revenue Department of the Government of Assam have not responded to the same. Where is that scheme? Somewhere I saw that scheme somehow. I've heard the learned counsels for the parties. Although the petitioner herein has claimed entitlement for an amount of rupees 5 lakhs on account of some scheme for grant of ex gratia to the martyrs of the Assam agitation of an amount of rupees 5 lakhs. But such scheme has not been enclosed to the instant petition. The respondent authorities have also not produced any such scheme. This court also finds it relevant to observe that the respondent revenue department also in spite of various opportunities being granted, have not filed any affidavit stating their objections that a nephew of an unmarried martyr would not be entitled to the ex gratia. And under such circumstances, this court has to assume that the revenue department of the government of Assam duly accepts that the nephew of a unmarried martyr would be entitled to would be a next of kin for grant of ex gratia payment. Be it as it may, as the said scheme has not been enclosed, but there are only correspondences between the authorities which shows that there is some scheme. This court directs the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department to verify whether there is any scheme for grant of ex gratia amount for the next of the kin of the Assam martyrs of the martyrs of the Assam agitation. And if such scheme exists, the petitioner be paid, disbursed an amount of rupees 4,70,000 in a be paid, be released, disbursed an amount of rupees 4,70,000 within a period of 3 weeks from the date a certified copy of the instant order is served upon the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department. The said amount of rupees 4,70,000 has been directed to be paid subject to existence of the scheme on the ground that an amount of rupees 30,000 has already been paid to the father of the petitioner earlier. Oh, that's shopkeeper policy. You brought on record. You filed the affidavit today. Mr. R. Goswami appearing on behalf of the New India Insurance Company Limited. submits that the affidavit has been filed today, bringing on record the shopkeeper's policy to list the matter after the puja vacations.
Let me one more mistake.
Yes, one more.
For a policy, terms and conditions. Filing is a terms and conditions, most important that is there. The policy schedule, I think,
Huh?
policy schedule is there already on record, just based on this. But I want to be complete with policy schedule is a terms and conditions. What I find is the terms and conditions.
And whatever maybe I'm having it after the puja vacation, bring it on record those things.
34.
You're filing the affidavit? You have filed it? When? No, today. You have to file it on 15th. Then if you don't hear it, why should we not? You want to file it? Mr. N. Goswami, the learned counsel appearing on behalf of the respondents, submits that the affidavit which was directed to be filed on 15/9/2023 have not yet been filed. He submits that another 1 week would be required for filing the same. This court fixes the matter again on 16th of October 2023, thereby giving the liberty to the respondents to file the affidavit by 13th of October. At the time of filing of the said affidavit, the respondents shall deposit the cost of 5,000 rupees. 7,500.
36.
Hmm.
Some of which, 76,000, but that is security.
Then, Huh?
Security deposit amount has been deducted, although the work completed in the year 2018. We have been paid in the year 2020, deducting the security.
so you have not got the security report. Why you have not paid? Huh?
The instruction is not. The project is not get conference today.
Is yet not functional. No, but how that the amount is lying with you? He has completed the work. Then why you are not paying him the amount?
Usually paid losses
When?
by December losses. They are for the instruction.
December? Instruction? Else we are imposing costs thereafter interest on who has given the instruction?
Instruction is not prepared. After being, I'm sorry.
No, there is no question of functioning. He has done his work.
I again asking.
No. You see, you pay by 15th of December, failing which, where is it? The said security will be released as soon as the year will be functional. Why is it not functional? As per your contract, when it was to be released?
After I have completed the work, they have charged it on 1st February 2018. Electricity charging was done on 1st February 2018. And after it, even after filing of the hit, I have been paid substantial amount deducting the city. Initially, they have not paid, so we can.
Till what time can he retain the security deposit?
Maximum 12 months, that was the defect liability period.
Defect liability period is over. Then, when are you paying?
December. By December.
15? thereupon interest from that amount, from the date he is entitled to, at a rate of 12% to be paid by the department, and the department shall not be at loss. They will collect it from the salary of the executive. The instant writ petition has been filed by the petitioner, claiming an amount of rupees 27 lakhs 62,996, to which the petitioner is entitled to as per the admitted liability by the irrigation department of the government of Assam. It has been submitted that during the pendency of the instant writ petition, the entire amount has been paid, save and except an amount of rupees 2,76,300 have been retained. Good stop. The learned counsel, appearing on behalf of the petitioner, submits that the respondent irrigation department cannot further retain the said amount of rupees 2,76,300. Inasmuch as even the defect liability period is over. Today, when the matter is taken up, Mr. Anupaide, the learned counsel, appearing on behalf of the irrigation department, has placed on record an instruction issued by the executive engineer, Hazo Jalukbari Division 1, to the chief engineer irrigation department, stating inter alia that the security deposit amounting to rupees 2,76,300 has not been released, and the scheme is not yet functional till date. The aforesaid security deposits will be released as soon as the scheme would be functional. This court have duly taken note of the said instruction is kept on record and marked with the letter X. This court has duly taken note of the provisions of the Contract Act, the provisions the terms and conditions of the supply so made by the petitioner, and from the above, and on the basis thereof, it is the opinion of this court that the respondent authorities cannot retain the security deposit beyond the defect liability period, which had expired 12 months after the installation, supply or installation.
Charging of the electricity line.
Charging of the electricity line, which was done in the year 2018 itself. Mr. L. Under such circumstances, this court therefore directs the irrigation department of the government of Assam, and more particularly to the chief engineer, irrigation department, Assam, to disburse the amount of rupees 2,76,300 to the petitioner within 15th of December 2023. Within within 75 days from the date of submission of the certified copy of the instant order to the chief engineer irrigation department having his office at Chanmari, Guwahati. it is made clear that if the said amount is not disbursed to the petitioner as directed herein above, the petitioner, in addition to the other remedies available for non-compliance of the directions passed by this court, shall be further entitled to interest at the rate of 12% from the date on the said amount of rupees 2,76,300 from the date of the instant order. Full stop. This court further directs that in the event, in such event, the irrigation department shall also take appropriate steps. Irrigation department, that the commissioner and the commissioner, the irrigation department shall. No, it's okay.
Regarding reclassification of the land under the on last occasion, we noted that whether lands were acquired under any sector.
Shall produce the records in respect of in as much as nothing is clear under what provisions of law the land of petitioners have been acquired. Yes, now what is your prayer?
Of the lands acquired. They have immediately filed objections before the deputy commissioner during acquisition.
You want the reclassification and the deputy commissioner has passed an award. Has the award been passed by the competent authority?
In my.
Huh? No, has the award been passed?
Yes,
Award has been passed. Then what did this court have to do? Huh?
page 22.
Page 22. Page 22, statement of AR acquisition for development of multi-logistic park and so and so. Okay. No, award has been passed. So if the award has been passed or the order has been passed in terms with section 3G, 1, then what are you doing here?
Already filed objection also, that was not taken from.
No, you have to file an objection there. When did you file the objection?
That time, COVID period was there during the time of acquisition worship. First gazette notification, I have taken the objections, they have filed. The first gazette notification was on 25/2020.
Oh, yeah. Wait. This is your thing. Copy of the notice of the petitioner, copy of the award schedule, copy of the notifications under so and so. This is for your info, so and so. Okay. Now, when did you file that award? Your objection?
First January 2021, 22nd January.
Where is it? Where?
I have not an project.
And you don't have a case then. You should dismiss it on that ground itself. Yeah. Non-consideration of the application filed in the year 2000 for reclassification. You want the reclassification to be done by whom?
By the deputy commissioner.
They have not done it.
Act project. For that act, deputy commissioner is the competent authority for reclassification of the land.
Then,
That is Assam Agricultural Land Regulation of Reclassification and Transfer of Non-Agricultural Purpose Act 2015.
2015.
Yes.
Then,
As per that act for construction has to be done by the deputy commissioner. So according to green
You want the reclassification from what to what?
from agricultural land to non-agricultural. Then Lordship automatically my award will be enhanced. Your Lordship will find my annexure one.
What is your basis?
They have served me a notice that you are using the plot of land as a non-agricultural purpose. So why you are not applying for the reclassification? That annexure one I have appealed for. Page 15 and 16.
This is done under the 1936 Act or
Yes,
63. Hmm.
right. They enclose
You are
the
informed to fill up the
application.
enclosed form with the relevant use for store coal for the purpose of business instead of being used as a restoration. Using the land for business is identified as industrial storage. So now, what do you want to say?
With that, of this Lordship, an application was forwarded to the petitioner. Lordship, he accordingly submitted the same in the year
When was this?
2012. The
What?
Lordship find the date below the original copy, the 3/3/2012.
6?
3/3/2012.
Where? Oh, 3/3/2012. Okay. And then when was this acquisition done?
And since then.
And when did you file your application?
Application process we immediately find in the year.
Where?
2012. That copy I do not have process, but in the second application I have that copy and I have annexed that also. So they have not filed any application in opposition in that case.
Here they have filed an affidavit. What do they say?
I have not filed in the year 2012 after acquisition, I have filed my claim.
Yes, that is a proof.
But Lordship, I am paying all the revenues in enhancement.
Are you paying the revenues at the enhancement?
Yes.
Let us see.
That is.
Huh?
Is-
So you have increased the rates. Huh? Where? Without making an assessment, how can you do that? So you filed the application for 1/2/2021.
No, Lordship, that is for the second representation.
First representation is when?
Lordship, fine.
Why even in your application, you have not done so? In your reply, you have not enclosed. No.
In the next petition, I have that copy of the 2012.
Land revenue is being collected in respect to the land of so and so, Iman, till Iman, and the same land has been used for. Land is being collected in respect of so and so. Till revenue year Iman in respect of so and so. Halituli. Halituli would be? So here it is being said, it is done as per Halituli.
That is second rule.
No, here it says land revenue is being collected in respect of land measuring 2 katha 1 lecha, class Halitoli covered by so and so as industrial class. And in respect to the second petition, 1 biga 13 lecha, I think Halitoli, there it has been done as per Halitoli class. Till so the first petition, it has been done as industrial class. Second is Halitoli.
Second petition, your Lordship will find my 2012. that application I have annexed. with
So
the
they,
second. In that case, they are not denying that I have not applied.
then,
In that case, they are saying that I am not paying on enhancement. And in first case, they are saying I have not applied in the year 2012, as that copy I do not have. But in second application, in page 29, I have annexed the original copy.
in the first writ petition, have you mentioned when did you file immediately?
That I must have-
That also you have not mentioned.
But my father applied and now about the one is the son of the original one. But lawsuit will find there is a format they provided with the notice. As per this format notice we apply.
Chalo. In the second writ petition, you file your affidavit. File it. And bring on record these instructions. Mr. N. Goswami, appearing on behalf of the respondents, the respondent authorities, submits that although affidavit in opposition has been filed in WPC number 7113/2021, but no affidavit in opposition has been filed in 4190/2021. The state would like to file an affidavit in that regard. This the matter again on 16th of November. The affidavit be filed by 14th of November. On or before 15th of November. Arvita likhi dibo, huh? During the course of hearing, Mr. N. Goswami has also placed certain records, certain documents which have been sought for by this court by the order dated 14/8/2023, which is kept on record and marked with the letter X. Hearings complete. Hello. Matter for what?
Allowed by the original weekend, my land was inside the boundary wall of the point. So,
Okay. Now, as the please the matter on 2011/2023. On which date an attempt shall be made to dispose of the writ petition.
I don't put it for the.
Yes, service complete. Mr. H.K. Sharma, the learned counsel, appearing on behalf of the respondent, petitioner, submits that he would like to take fresh steps upon the respondent number 7. He may do so within, he is directed to do so within 7 days from today.
41 to 53.
And people did say, because what they have made false state, because it's not evident, because right in the compare, there's admitted that this amount is due to us, and because of paucity of funds, we have not been able to pay. So this on the phone director said, you make the payment of the fund, or else the people invest in it. Kipling was not there, he was here, and then he was asked to pass a recent order as per the direction on something for recent order for the purpose of making a bill. Then in the recent order, he says, we are not liable to pay any amount because they are not even in the MSME. They have questioned my MSME paper also. And still, they are not liable. So one of them has lied and lied on both before this order.
So that is something I would like to bring to your lordship notice. This is a very serious matter. The order they have passed.
In which case you are referring to,
The document, look at it, item 44.
which is the
42, 101.
101, yes.
Document that happened in FD. I have filed an affidavit also against it.
The contempt arises out of an order dated demand wherein the following, having regard to the submissions made by the land council and the representative dispose of directing the chief engineer PhD to consider the representation dated demand filed here for making payment of the outstanding with interest within a period of 3 months from the date of receipt of this order. Although the respective of them have been filed with the response projecting that certain amounts have been released. However, it is always the limits that in terms of the direction of the scope of amidst that there is an importance created by government in customs and of passed by this court in another matter wherein the directions was issued to the department to institute an inquiry. Yes, who is being for the respondent?
Lordship, I am appearing on behalf of our council hard over. Lordship, I have been instructed to submit that this.
Mr. Counsel, first and foremost, you may be first new to this court, but no lawyer appears for any lawyer. Unless you have a wakalatnama for him. You have a wakalatnama? No. So you are appearing for someone and you are not appearing for anybody, then we'll hold that the contender is not present before this court. We'll ask his personal appearance and we'll dispense with the whatever benefit which we are giving to be represented through accounts. Now tell me, are you representing the contender or not?
Yes, sir.
Okay, now tell me.
Lordship, I have been instructed to submit that the concerned speaking order is already under challenge in a writ petition. And therefore, nothing remains of this condemned petition. Lordship, I have a copy of that order with me.
Madam, don't you think that this matter needs to be listed along with that?
I think so, Lord.
Because you see, I can't pass an order once you have already challenged that order.
But that is challenge. It's not whether that order is good, bad or ugly on that. But here, I am not concerned whether it's good, bad or ugly. I am concerned only about the fact the chief engineer, the different chief engineer town, he made two different statements.
But if you want that, don't you for want to file it, you have to, this will be an action under 340.
Yes,
So we have to, if we are to take into account that, then this has to be brought on record by way of additional pleadings.
I do that.
I think that has to, if you are not on this contempt, but on the basis of false statement being made.
Exactly.
But that thing can be very well mentioned out there in that writ also.
I can do that. So let it be that.
I think better off this contempt proceedings. This only 101, na? Have you challenged all the matters?
Three matters that one, I have just.
You have only this 101 is guard.
Yes, that are challenging.
This it is 1012 the Maha contempt case 1012. List the matter along with WPC number 4631 oblique 2023.
The others also might.
On such date as the registry would list WPC number 4631 of 2023.
Item number 41.
Huh? No, SRK? SRK also you have filed? Same to, it will be to AK order over to 5275 of 2023. 23. 527, list with WPC number 5275 of 2023. On such date as this, the registry of this court shall list that Hikon WPC number 1.
The other one I have not filed. Comes for 70 days.
List this matter after you are filing, I suppose. List the matter immediately after the puja vacations. It will be like so segregate with 7-3. Make it correct, otherwise this matter will go there. 82 matter to list this matter after 103 will be list the matter after puja vacations. I think it a hit take that. You can avoid you, huh? It's a reply.
As per last order by the Lordship, we were asked to take fresh steps. But your Lordship, we could not face the new address of respondent number 4. And therefore, Lordship, we received permission.
Respondent number
4.
what is this type of matter? Why are you making the respondent number 4 a party?
Lordship, it's for washing the FIR.
Quashing of an FIR. FIR filed where?
Filed in Andhra Pradesh, Visakhapatnam.
Why you are challenging here?
Lordship, because they had filed a similar FIR here in Guwahati, and for which a final report was submitted. And now again, a similar FIR has been.
Let's see the contents of the FIR. Which is the FIR? 18/5/2019.
Yes.
Where is it? 18/5/2019. Where is the English translation? My name is so and so, and my husband name is so and so. Since time I'm married, he has physically assaulted me on so and so. He used to call me to committee, and since I had no one day used to scold me, and at times he used to threaten me with knife. He used to beat me by saying that he belonged me to implement the people of their part. He used to talk to him politely and then going to the after I returned to the doctor, he used to touch me actively at home. He used to scold me that you are forcing me and whenever he about the ability So the investigation is going on.
Yes, Lordship, but there's an interim protection order already passed by this honorable court.
Not to take coercive action.
Yes.
Coercive action is okay, but can this order be passed in view of the Niharika infrastructure judgment?
Lordship, right now, Lordship, I have been instructed to seek permission to publish the notice because we have not been able to find the address of the respondent number 4 because.
The address is there, must be there somewhere in the first information report.
Lordship,
District Visakhapatnam, year so and so. Address of the year would be there, complainant address is there. So and so, resident, village, flat number 105, first floor. Have you given that address?
yes, Lordship, but every time we attend it, the service is not be completed because.
Why you are not giving it flat number 105?
Lordship, that is the address where we said. But
No, it is not there. Your name is resident of first floor. Leased apartment, apartment spelling wrong. This is why it is not. Guzuaka. Visakhapatnam, Andhra Pradesh. Now we have the name of Visakhapatnam.
yes, we,
The district may be Visakhapatnam, but do you have the name now? Vizag? What that? What is the name? Do you have the name of Visakhapatnam?
Lordship, we attempted several times to.
The learned counsel for the petitioner is directed to file the learned counsel for the petitioner submits that he would like to take steps by way of paper publication at the address at the last paper publication, taking into account that the how many times have you taken steps?
Lordship, 4 times.
How do you say so?
Lordship, it will be reflected in the record. First time we sent it on 21st January 2020, and the last one being 7th January 2023.
Insufficient address. Now respondent number 4 does not reside there. Huh? How do you serve it?
Lordship, hence we are seeking notice by the district also.
Where?
Lordship, perhaps in Guwahati, any newspaper of wide circulation.
What you know? FIR is there. Visakhapatnam. You have to at least do it in 4-5 newspapers out there in all the languages.
Lordship, will-
English, Telugu, as well as Hindi also.
All right, Lordship, will take those steps.
First, you get all of your address. Where is she?
Lordship, we made several attempts, but we.
You don't know.
Yes,
Where's the husband? Husband doesn't know where the whereabouts of the wife.
Lordship, it is one of the allegations that the petitioner is a husband, but Lordship, that is not true.
You have no relation.
That is just an allegation.
Are you denying that?
Yes,
That you are not the husband?
yes, Lordship, that's not been accepted by.
Oh. Bombay also this is filed. This has been filed by some Abha Sahu. Who is he? Your first wife?
Yes.
So that first wife has done that. Then you have filed it at Azara police station.
No, Lord, that was filed by respondent number 4.
Who is she?
Uh,
Her name is Abha Sahu.
no, Lord. Her name is
I, Mrs. Abha Sahu, residing at Pawan Hans Colony, Santa Cruz.
But that's a FIR filed by the petitioner's wife, evening. Because their claiming harassment by respondent number 4.
The learned counsel for the petitioner shall obtain the instructions within a week as regards the current place of address of the respondent number 4. List the matter on 4th of October 2023.
45. And 46.
Yes.
46 says that we have approached it on court. And this is some more allowed after once the contract, that's allow them.
No, no, why the matter has come to them, Mr. Khan?
Other there is contempt is pending by one.
Contempt for what? Affidavit in reply filed by the petitioner has been received and placed on so and so. Okay, we'll have it when the service is no problem, no? Okay. List the matter. We have to fix 1740 for admission. We'll have it in admission. Huh? No, contempt doesn't come for admission. Yes. List. List WPC number 1795/2019 along with contempt case number 426/2020 for admission immediately after the recess. Comply with. Yes, what is it? 47? You are asking for confirmation of an interim order. You are not placing. Are you going to Yes, what is this? You are not placing this? Mr. P. Singh Raja, P.S. Raja. Huh? Your name? So and so appearing on behalf of the applicant submits that the applicant would not like to press the instant application. Accordingly, the I is closed. Now tell me what is the main thing? Has been issued on so and so, affidavit on behalf of the petitioner on has been received and same. None has entered appearance and none has entered appearance to upper as per affidavit notice were received so and so. Then, you have served it. Taking into account that the service have been duly effected upon the respondent number 3 and 4. This court, the service upon the service being complete. Taking into account the affidavit filed on 19/9/2020 by the petitioner, wherein it has been mentioned that the respondent number 3 and 4 have duly received the said notices The service is complete and accordingly complete. Accordingly, list the matter for admission on immediately after this to the result.
48.
None appears on behalf of the petitioner on call. Be that as it may, a perusal of the contempt applications reveals that a perusal of the contempt application did not show that the certified copy of the order have been served upon the alleged contemners upon the respondents prior to initiation of the instant contempt proceedings. Under such circumstances, the instant contempt proceedings is not maintainable and is not maintainable. Be that as it may, the be that and accordingly stands dismissed. Be that as it may, the dismissal of the instant proceedings on the ground of maintainability shall not preclude the petitioner to approach the concerned respondents, approach the respondents in WPC number 3063/2020, seeking compliance if anything, seeking compliance, if permissible, seeking compliance, subject to any cause of action remaining being subject to there being and subject to any cause of action surviving. The instant contempt application has been filed, the instant contempt proceedings have been filed for non-compliance with the order dated to the order dated 11/2/2021 passed in WPC number 9510/2019. A perusal of the order dated 11/2/2021 shows that this court had directed to make necessary verifications and to make necessary verification as regards the entitlement to the notification dated 15/11/2014, and it found entitled to make the said payment within the time frame. Ms. P. Bordloy, appearing on behalf of the respondents. S. Bordloy. N. Bordloy. Appearing on behalf of the respondent submits that the petitioner herein have already been paid the said amount after necessary verifications being carried out. To that aspect, the sanctioning order dated 24/12/2021, as well as the budget allocation dated 17/2/2022 have been placed on record. Full stop. The same is kept on record and marked, and that the same is kept on record and collectively marked as annexure as with the letter X. In view of the above, the instant proceeding therefore stands closed. And in view of the above, as the order has been duly complied with, the contempt proceeding stands dropped.
50.
Somebody died. Then what are you going to do? The learned counsel appearing on behalf of the petitioner submits that as the respondent number 3 had expired, which is apparent from the Lozima Court's order dated 14/9/2023, the petitioner would be taking steps, appropriate steps in that regard. Have you taken steps? No. List the matter after 6 weeks.
51 and 52.
The service of the respondent is complete.
4.
Please complete, and for 4 these claims, we are going to file
No. Let us go. Item number, who is appearing for 1650?
1650 and
Wait, in 1650, let us see who is appearing for whom. Yes. State Nalbari Municipal Board, who is appearing? Okay, complete. Soilen Bharali? Okay. And Deputy Director, Town and County Planning, there's some department there. Okay. The service, it would is 1650. From the record, it reveals that the service is complete, and as such, list the matter for admission after the vacations. E2, what has happened to the other matter? The 52. Who? You are appearing for the? Oh, you are the petitioner.
Yes, sir.
And you are the private respondent. Okay. Same matter. Here too, sir. Here, what is the interim order? As regards the building be maintained in all respects till the return date. Okay, Econo Depot lists the matter along with WPC number 1650/2021. The interim order passed earlier shall continue till the next.
If we say
Yeah, আগৰ method till list the matter on so and so with there on আগৰ ডেটটো দিছো নে এইটো নাই দিয়া admission এইটো দিছো না we fix it on the vacation দিছো this for admission when the vacation দিছো না the list for admission on 2011-2023 আর এইটো দিব for Iman 2011 for admission. And it would list for admission on so and so 2011 along with WPC number he2. Interim order passed earlier shall continue. The second. Yes, Oriental Insurance.
That's why last order, taking over the number.
You have taken steps. Despite order dated, notice has been issued upon the respondent number 1 by usual process. Okay. You have to take steps upon whom? Okay, usual process as well as register. Huh. Taking into account that the petitioner had duly taken steps.
Heading for the respondent number 3 and 4. But in this case of this pending since 2021, and also service has just been completed as this same. But also respondent number 1 and 2, I think it is not required in this case. Usually for them a stay order has been passed against us because of that export stay order. It's pending since the last 2 years. I am the insured person.
Huh?
I am the insured person.
1 and 2
The 2 is the ombudsman, that is the tribunal which passed the order.
are not necessary. What is the case?
There was an order passed by the insurance ombudsman.
Hmm.
And it was passed in my favor that the award should be passed immediately, passed upon us within 1 month. Actually, after that order, after 1 year, they never passed the award in our favor. After 1 year, they approached the Honorable High Court and they took the stay order. And since then, this case has been now listed for.
Okay. But he's suffering.
That's
Why didn't you appear on the last occasion?
some inadvertence.
There the problem arises. Now, when I have already passed an order directing him to take steps upon the respondent number 1, now can this court go otherwise? Tell me. Tell me. It's all because of you. You could have made this statement. Can't help it. Taking into account that the petitioner has taken steps upon the respondent number 1, list the matter for admission on 8th of November 2023.
Clarify my affidavit statement.
Respondent, the council appearing on behalf, the respondent number 3 and 4 shall file the affidavit in the meantime. And attempts, Mr. What's your name?
AGM.
Agent appearing on behalf of the respondent number 3 and 4 expresses urgency in the matter. Under such circumstances, list the matter on the next date. An attempt shall be made to dispose of the writ petition.
Yeah, all right.
54.
But order of the notice, 49, service is complete for all respondents.
What is this type of matters?
Non-payment of contractual dues.
Huh?
Non-payment of contractual dues.
How are you bringing the BCCI here?
Now they are looking to infrastructure fund is provided by the BCCI.
So what? What is this BCCI making a party? Go and file a suit.
But the HCA is a member of BCCI and infrastructure fund is provided by the BCCI.
So? And so what? How are you making this AC a party? Tomorrow you will resort to everything. These are associations registered under the 1860.
That is it.
Then
But there are judgments saying that BCCI is a public servant and when this application is maintained.
fantastic. You take that. This court is not going to do that. We'll dismiss it. You go to division bench. Let the division bench take a call and pass such orders. This court is not going to pass such orders.
Lordship, this question is pending in other two restrictions in many restrictions, Lordship. This has come for orders today, Lordship. It's for admission and maintainability. is kept
My
open.
time is still there till 5 o'clock. Don't worry. This is the case to be
Maintainability is kept
dismissed.
open.
What maintainability is kept upon? How do you ask all these things? Tomorrow you are going to ask for anybody else?
Lordship, this issue will be decided, Lordship, along with the other petitions. Lordship, will keep it for admission. Lordship, will argue that out.
What is there to argue? You'll argue with the only thing which I have to say. That you are saying about Z Telefilms.
Lordship, Bihar Cricket Association.
That is Z Telefilm.
Yes.
Then what is so what? That is for another purpose. Of payment of contract. These dues are to be made by ACA. You are saying that BCCI is paying, and as such, ACA has to pay.
Lordship, these funds,
Yes.
in other institutions, there are affiliated documents which says that in BCCI.
Let us assume the BCCI has paid them. Let us assume the BCCI has paid them.
50% of the interest.
Understood, the BCCI has paid them. Then we have a right against the BCCI. We have a lien against the BCCI. I'm asking you. Do you have? No.
These stadiums, we have made.
Do you have a contract with the BCCI? Tell me.
Ultimately, the funds will come from BCCI.
So,
BCCI
do you have a contract with the BCCI? Tell me.
No,
Let us remove response number 2 to 6.
but if BCCI is not there, how ACA will get the funds? ACA is a full-time member of the BCCI.
So,
But they are bound by the constitution of the BCCI.
so that the constitution of the BCCI say that the ACA has to pay.
But we have made the stadiums are complete, the international.
I'm not concerned whether you've done or not. That is your lookout. You go before the civil court. That is absolutely your lookout. I'm not on that. I'm asking you, let us assume BCCI is a state.
No,
Or forget about BCCI. Let us assume the state of Assam is paying the amount to the ACA. Do you have a privity of contract with you and the state of Assam? No.
no, but
Do you have a right to claim that the state of Assam will pay the amount to ACA and therefore I'll have a claim because the part amount comes from there? Goodness.
These questions will come up, in the admission.
Fantastic. List the matter on 25/9/2023 on the admission stage on which state the learned counsel for the petitioner shall satisfy this court on the maintainability of the repetition.
Along with the.
I am not concerned with others here only. Why should I hear other things? I hear this and this piece. Then the three will follow with that. Yes.
That is the problem.
Yes, what is this MC? None appears on the Bihar. Yes, you have not appeared on the last occasion. What is this I for? Dismissal, restoration. Huh? Restoration of a matter which has been dismissed by recalling the order dated so and so. Order dated? When did you file this application? 2023, after 4 years. Why? Huh?
Only after. Done my work. Change my work.
Page?
Page 25.
Chalo. Let us issue notice. Notice to whom? Whom should we issue notice? Yes. issue notice. Issue notice making it returnable by 6 weeks. The petitioner is directed to take steps. Issue notice making it returnable by 6 weeks. Mr. H. Sharma, and who appears for the revenue? Okay, and no revenue. We make it Ms. P. R. Mohanto, the learned counsel, and SC revenue, and Mr. S. Burwa, the government advocate, accepts notice on behalf of the respondent number 1 and 2 respectively. As regards the respondent number 3, 4, and 5, the petitioner shall take steps by way of registered as well as usual.
Thank you.
56.
Okay, we will none appear will delete, no? Over a delete. List the matter, next picture. Yes, Mr. B. N. Gogoi.
Sir, why did the apology not be-
No, anyways, I'll put it to you, your appearance, but that has to be dismissed.
Only one point. Let me go to the passport with demarcation of the land. And
Which one?
57, 47.
The contempt?
No, the one case matter is, I don't know, 48. I was non-appearance, but.
No. 48 I didn't do so. There was some contempt matter. It was a contempt matter.
I had filed one file for contempt and another for discussion.
The repetition, I'm not touched it. I won't. Contempt only, I say that as you have not issued any notice, so it is not maintainable. However, giving you the liberty to serve and then approach. But you without issuing a notice, how can you have to enclose that? No, that is not that a part of your contempt proceedings. See, you have a contempt petition. See,
But you have already issued the notice, you have also clear, already issued.
at the time of filing the notice, petition, have you issued the notice? Then without that, how do you vote? A contempt is willful violence. Can you do it? So therefore, I gave it a liberty. I closed it, saying that it is not maintainable. However, liberty is given to him to serve copies and thereupon approach this court for non-compliance if cause of action subsists. That is what I order.
Did you read this?
Repetition, I am not saying it.
I want one. Last occasion also I asked the matter, but you asked me to go and get it from you came. I only said, let me pass an order by this order.
Okay, some repetition concern?
12/8/2020, only 10 months.
Huh?
This honorable court already passed an order dated on 12/8/2020. On the basis of this, order, this order.
Okay, we'll do one thing, the here repetition con, the service is complete. This is the matter on 27th. We'll fix it on 27th for admission. They're gonna actually give a repetition. That repetition is not there on record. That repetition is not come up. That is the why. Which one? Repetition is not there today in the file. You mentioned the matter, we'll take it up on 27th. That is the only way.